Justice of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business before this court will come there, give their attendance, and shall be heard.
Thank you. Please be seated. Good morning. The first case on the calendar for oral argument today is People v. Derek Peace, case number 904, People v. Peace. Mr. Schifrin will be arguing remotely. Schifrin, good morning. You may begin. After you unmute yourself.
Good morning, Your Honors. Brian Schifrin on behalf of Derek Peace. If I may, I'd like to first address point 2 and then go back to point 1. In point 2, we argue that the photo arrays in this case were impermissibly suggestive because this is a case in which the shooter was described as being a light-skinned black male, and the only light-skinned black male in the array was a photograph of Mr. Peace. A suggestive photo array is one in which the viewer's attention is drawn to one person. We urge this court to view the arrays which are included in the appendix of both pages A77 and A79, because we're confident that any person not having viewed the actual crime, but just hearing the description of the perpetrator as a light-skinned black male will select the photograph of Mr. Peace. That is the definition of a suggestive array. Investigator Brown, knowing that description and knowing that Mr. Peace is a very light-skinned black male, testified that she did not use skin tone as a factor in selecting photographs to include, that she selected some photographs of people who were very dark-skinned black males, and that she altered only the photograph of Mr. Peace. As a result, the only person in the array whose photograph matched the description was that of Mr. Peace. The cases cited by the people are easily distinguishable. In People v. Hicks, this court wrote, the photographs were sufficiently similar in appearance so that the viewer's attention was not drawn to one photograph. Again, that's not the case here. In People v. Stanley,
we do have that photo array in the record.
That's correct.
I think we can take really a close look at that when it comes time to decide whether it was suggestive or not.
Thank you. I'm pretty confident. I did a simple test over the last 6 months, and show a person the array, say the shooter is light-skinned black male. 100% of the people
Your whole argument is premised on the light skin description. Otherwise, they look remarkably similar. There's different shades of skin color there, but I guess your point is that if the witness hadn't mentioned skin tone, then it's totally fine. I mean, I looked at that array very carefully, and wow, the investigator did a good job of picking out people with similar features and beards and so forth. But we will take a close look at your argument on the skin tone to see if that swings the balance.
But counsel, can I just ask you one question? Even if that were the case, would that error be harmless based on all the other facts in this case?
Well, actually, that brings us right to the weight of evidence point. This is a case where there's no admission, no confession, there's no forensic evidence linking Mr. Peace to the crime. No gun was ever found in his possession. This case depends on 3 eyewitness testimonies. One is the testimony of Doris Allagood, who 4 days after the shooting told the police, "Oh, I knew all along that the shooter was Derek Peace." Yet on the day of the shooting, she gave a very detailed description, didn't mention that. She was asked by Investigator Brown, "Do you know the shooter?" And Investigator Brown said no. She said she did not. So over the next 4 days, Investigator Brown showed her photos of other possible suspects. The explanation by Doris Allagood as to why she waited 4 days is simply false. She testified she was unable to communicate during those 4 days because she had been shot. Yet the testimony not only of Investigator Brown of multiple conversations during that period, but the doctor who treated Ms. Brown testified that she had no problem communicating. So to rely on the clearly false testimony of Ms. Allagood as a basis of conviction would be improper. Her sister, who has no claim to have ever seen Mr. Peace prior to the event. This was an event that occurred at night. a person wearing a mask and a do-rag approached with a gun, started shooting. Sister Sharan testified she then understandably turned around to try to flee, and she was shot in the back. So you have short event duration, you have stress, weapons focus, and Sharan described the perpetrator, the shooter, as being light-skinned. So she's shown a photo array in which the light-skinned person is Mr. Peace. Not surprisingly,
Mr.
she picked out
Schifrin,
Mr. Peace.
I tend to agree with you with respect to the two eyewitnesses, the sisters. If the case were based on their testimony alone, I would be inclined to agree that the people did not prove your client's identity beyond a reasonable doubt. What the people seem to place a lot of focus on is testimony of Miss Martin, and who knew your client very well, saw him every day for a year, she claimed. She identified him in the video, and then the incriminating evidence with respect to the seemingly identical T-shirt and similar shorts found in your client's laundry that matched the clothing, that seemed to match the clothing of the shooter. Those are the two big pieces of evidence, if you want to address those.
Sure. Miss Martin is easy to address. Miss Martin, who's shown a grainy video, and I don't know if the court's seen it, it's an exhibit.
We have.
Months after the event, is told by the police prior to being shown the video that the shooter is Mr. Peace, and you're being asked merely to confirm the identity of the person on video as Mr. Peace. That is incredibly suggestive. The way you conduct an ID procedure is not to tell the person and see what the person says.
You don't suggest that her testimony was incredible. In other words, she had a motive to lie or anything. You're just saying that she was influenced by the fact that she was told who she was supposed to look at.
Well, actually, both, Your Honor. First of all, as you just said, she was influenced by, she's told in advance as Mr. Peace, and she does have motive because, as the record shows, that she had a separate incident. The reason she hadn't seen Mr. Peace in at least 5 months is she brought allegations against Mr. Peace. She claimed that he had threatened her. So she is mad at Mr. Peace, and she's told Mr. Peace was the shooter. Could you ID him? And she admitted you can't see the face of the person on a video. This is not a reliable identification upon which you can base a conviction for someone.
You can see part of the face. You can't see the whole face. It looked like one of the COVID masks that covered partially. But in any event, what about the clothing?
It's our contention, Your Honor, and look, the clothing is not unique. There's a pair of shorts, and there's a Levi's shirt, and there's no indication that this was there's an unusual shirt or shorts. So to pin again a double attempted murder conviction, my client's facing 48 years in prison on that is, I think, would be wrong. These ID, if you just had the clothing without these IDs, this court would not be affirming this conviction. These IDs don't give a false veneer of weight, but each of them individually and cumulatively, for the reasons I've discussed, are unreliable. And they're unreliable because the police engage in improper tactics with not to consider the description of light skin and making a photo array, created incredible danger. That this court said, well, these two women both said it was him, and then you have Ms. Martin being told it was him. To countenance this is to have a risk of a conviction by misidentification, and therefore we urge reversal of this conviction. Thank you, Your Honors.
Thank you, Counsel. Mr. McCarthy.
Thank you. Good morning, Your Honors. Marty McCarthy for the people. I'm going to start with the weight point. Here you have two witnesses who positively identify the defendant who were the victims of the crime. You have a third witness being Ms. Martin, who knew the defendant for a year and not only identified him as well from that video. And I watched that video, and two things I would not describe that video as being is grainy or poorly lit. I felt that video was pretty clear. I thought it was ID quality. And Ms. Martin testified to all the characteristics you would ask somebody to testify to if they were going to make an identification based on a video identification from the Court of Appeals. All those factors were addressed. She talked about his gait. She talked about his mannerisms. You can clearly see his beard. You could definitely see his physical shape. All of those things are more than enough to provide her an ability to identify him. Also saw him with a gun the day before.
The clothing, am I correct? It was found in his laundry hamper. How soon after the shooting did they find the shirt and the cutoff jean shorts?
I can't say for certain. I'm sorry, I didn't write the brief. I know, I believe it was at least 5 days, but I don't know.
And they were both together in the same laundry basket? Is that accurate? I'm not sure.
I think so, but I don't know. And I would have to rely on the court for that. But when you talk about sort of unique clothing, two things to look at, right? The question is, the shorts themselves had a unique pattern to them. And you can clearly see that unique pattern on the video and the juxtaposition and compilation video with the photo of the shorts together with the video of the shorts. The shirt was a Levi shirt. I don't know how popular Levi shirts are, but
Well, it wasn't just a Levi shirt, it was a Levi shirt
With a
with
pattern.
some emblem on the
Yeah.
front, some particular wording
that
that's a little more unusual. It's just not a Levi brand.
So then the question becomes, okay, is equally, each article of clothing is equally unusual. The fact that both of them are found makes that unique. That's, I think, the way to look at the clothing. And to just touch on the point two briefly, the photo array was well constructed. There was a description of the defendant. That description was utilized by the officer who generated the array. The thing to bear in mind about the skin tone of the defendant didn't argue that below. He didn't make any arguments that that particular photo was more suggestive than the rest. And the court didn't find that, just to be clear. The court made a finding of fact that the defendant's skin tone was lighter, but he didn't go forward and say that fact alone did not make it unduly suggestive.
And I know you're standing in here, so this is difficult, but factually, did both witnesses, is it your recollection of the record, both of the sisters describe the shooters having light skin, or was it just one?
I thought it was both of them, but it was at least one of them.
Would you agree, looking at the photo array with Mr. Schifrin, that first of all, that's a factor? If somebody says somebody's dark skin, light skin, then you try to put, if you're making the array, you try to put people with similar skin tones. And second, that his client is lighter than the other 5 fillers.
I'm gonna start with the second part first. I would say that his client was lighter than the other 5, but I would not say that.
Not starkly lighter.
Well, I would say that one of them was, I think, darker than the rest, and I feel uncomfortable talking about it this way, but one of the fillers was, I think, much darker, and I think that photo was basically constructed because he met the general characteristics of the facial features. And when you talk about light skin, I think is a relative term as to what that means. And I think that can play into the fact that for the investigator constructing the array, they have to construct an array to sort of meet the amorphous characteristic of light skin as to what that means. So I would.
That skin color, that photo array did have other men of very similar looks.
Yes. And that's the thing. That's why I don't think it was stark. And it certainly wasn't enough to make the array unduly suggestive. There are no other questions. I'll rest on my brief.
Thank you. Next case for argument is number 905, People versus Ricardo Cousins. Morning.
Good morning. May it please the court, Melissa Swartz on behalf of appellant Ricardo Cousins. I'd like to start my argument by pointing out what my first argument is not. I'm not asking this court to find that because trial counsel called himself ineffective, not once, but twice, that this court should find that he was ineffective. That is not my argument. It would absolutely be an absurd rule to say if you call yourself ineffective, you are. I'm calling him ineffective because he was. He admitted that he didn't do the one thing that you fundamentally have to do at the beginning of your client's case, and that's to review the evidence against him. And it's not that he didn't review a singular witness statement or he didn't review, one piece of evidence. He didn't review the cell phone. And the cell phone ended up being the crux of the people's case against my
Counselor,
client.
as I understand your argument is, we were to know he didn't review the cell phone because he says he didn't review the cell phone.
As an officer of the court,
Right. So he sort of throws himself in the mercy of court. I'm ineffective and I didn't look at this stuff.
I disagree with the fact that he threw himself at the mercy of the court. What he actually did was cast aspersions on the prosecution by saying they never turned this over. They didn't turn this over.
That's where I want to finish if I could.
Yes.
Because the district attorney says, I've got records that counsel downloaded e-discovery on 10 different occasions.
Yes.
And the judge actually says to the attorney, you're telling me you're ineffective, but I don't believe you. I'm not buying this that you didn't look at the link. And your argument here is he didn't look at the link.
I disagree. I don't think the court says, I don't believe you. I think at some point the court says, I think you had this information, which I think is true. I do think he had the information. I do think it was downloaded by somebody in his firm. I think the issue is he didn't look at it. And I think if you look at the second time where he calls himself ineffective, he's actually very specific about it. He says, when you open the cell phone report, there's over 1,300 chat messages, right? There's no way, even if I reviewed every single chat string, that it would have dawned on me that, minuscule pictures and things of that nature, because why, Judge? He's extremely specific about it. I also ask you to look at his opening statement. His opening statement is really just this very surface level, reasonable doubt, but he doesn't try to attack, which becomes the absolute, definitive proof against Mr. Cousins. Why not? Because he didn't know it. He asks the prosecutor to play the voice note from Raven Watson twice. Why? Because the first time it was played was the first time I think he heard it. I don't think this is one of those cases where this court can say, send it back for a 440 hearing to see if this guy actually did look at the cell phone report or not. It's pretty clear from this record that he didn't. And if he didn't, we go to prejudice. And I point out in my brief 3 different times, 3 different things that prejudice my client. First, he wouldn't have been able to make an informed choice to go to trial, to reject the plea deal, and to testify on his own behalf if he didn't know the proof against him.
I think your first point is the big one because this record, look, harmless error doesn't apply. Even if you're entitled to meaningful representation, even if you're obviously guilty. And the proof of guilt here is just overwhelming. The trial lawyer for the defense, his summation was weaker than his opening. I mean, the theory, he was asking the jury to convict his client. I mean, there was just 0 chance with that summation. He blamed it on Mr. Brooks. But on the other hand, in the lawyer's defense, that was a horrible strategy, but was there any better one? There was really not much to do except to try to negotiate something short of trial. Once he got to trial and Sawyer's testimony comes in,
Yes.
it's over. Absolutely no shot this guy's going to win because he's just, again, the proof is just stunning. But I guess your point is that if your client's lawyer had realized the stunning nature of all this evidence and Sawyer's testimony, he would have, he should have tried to pursue a plea and advise his client. This is tough because we're not alleging that this guy intentionally said he was ineffective to give his client a new trial in the back pocket, but this does kind of open that possibility. A lawyer could, at trial, say, look, Judge, before we start, I just want to let you know, I didn't review everything. The discovery was voluminous. There was a big dump of cell phone. I didn't get to everything, but I'm ready to go. And then after trial, if his client's convicted, he says, look, I was ineffective, give him a new trial at some point. So there's that concern. I'm not saying it's an overriding concern, but you can understand if we rule in your favor, that opens the door to those types of chicanery.
That's why I started my argument the way I did, because I'm not asking you to find that. I want to just touch on 2 points that you brought up. And the first one is just the last one that you kind of started with was, does this open it up? And one, he's an officer of the court. I think we all need to assume that attorneys, ethical attorneys, are not going to lie on a record to a county court judge just to try to potentially exonerate their client or get their client a new trial. In my 12 years that I've been doing this, only criminal defense, I've only ever seen it twice where somebody has called themselves ineffective. This case and a different case when I was on the other side of the table. So I don't think that's something we should fear happening as lawyers, kind of not only opening themselves up to this court finding them ineffective, but malpractice claims. I also think we need to look at not just what he said, but all of the surrounding circumstances, because all of the surrounding circumstances in this case tell me, and I think it should tell you, that he didn't review the cell phone. And that kind of goes into the second prong of my prejudice, which was the Molyneux rulings. I think this case is extremely similar to People v. Stewart with Justice Lindley, Justin Ogden, you reversed in October, right? We have the court making errors, we have the prosecution making errors, and then we have defense counsel doing nothing about it. The people's brief in response to points, I believe 3, 4, and 5 of my brief were all that the argument you're making now is unpreserved. It's unpreserved because counsel wasn't prepared to fight against them because he didn't know what he was fighting against because he didn't look at the cell phone.
To that end, there's no argument here that those cell phone records were wrong, were fabricated in any way, was it?
I don't think there's any allegation that they were wrong or fabricated.
So I guess what I'm saying is, the defendant knew what those records would show. The defendant, created those records, so to speak, by participating in these phone calls. And why would he not have sufficient knowledge then to know what the evidence against him is likely to be? Because he actually participated in, those phone calls and those texts.
Well, he didn't defend himself. Counsel did. And counsel's the one that has the obligation to know the proof against him. But also the cell phone evidence, while I agree there's no proof that it was doctored in any way, it was unvetted and unchecked. And I think trial counsel's admission when he's about to present his case, and he tries to put in the belated records with Kamar Cousins and Kamisha Reed, that got denied because he wasn't prepared to defend against them. He also asks for an investigator to be added to his witness list. And he states, we didn't have money to get an investigator. That tells me that the cell phone evidence, the exchanges, they weren't investigated. So while they might not be untrue, we don't have the full context of what those conversations were or the potential other proof that maybe would have helped Mr. Cousins' case because, again, defense counsel never looked at the cell phone. Unless the court has any questions for me regarding my remaining points, I'm going to ask you to reverse. Thank you.
Good morning, and may it please the court, Morgan Mayer on behalf of the people of the state of New York. I'd first like to address an issue that came up a couple times during the oral argument, this issue of informed choices of making a plea. And I'd repeat my point that that's better argued in a 440 motion because there's not really much of what the defendant and the defense counsel had spoken of. We're not sure.
Well, there was an offer at some point of 8 years that the defendant flatly turned down.
Yes.
That was in some preliminary right before the suppression hearing.
Correct.
And that's when some of this material was turned over, though, was it not? I believe the trial prosecutor later said, well, I gave him all this stuff before the hearing, the suppression hearing.
Yes.
So I guess the defense argument on appeal as well, if my lawyer had actually looked at that before the hearing, maybe I would have taken 8 years.
I think there's an argument to be made with that, with going into defense counsel performance during trial. He says he didn't review this material. However, he did do a fairly thorough cross-examination on it. He was able to bring out other individuals who may or may not have involved an individual named Powder, I believe was brought up at one point. He was able to bring up the testimony from Investigator Halsey that this was not direct evidence of the defendant's guilt in this particular case. So I think there's evidence during trial that he reviewed at least part of it. We can't really go into the extent of it because we don't know the conversations that defense counsel and the defendant had, at least after that suppression hearing.
We have to look at his representation as a whole. I'm sure you've read the record as we have, the entirety.
Yes.
My take was from the very first day, it didn't, and I don't, no disrespect to this attorney, and it sounds like he had other cases going on, but I don't see many things he did right. I mean, he was late for court. He did, there was a trial date and then he was going on vacation and then he didn't tell the court. The judge was mad at me. He shows up late one day. Not a lot going right for this lawyer at any point in trial. Then he comes up with his theory. What did you think his theory of defense was at trial, the lawyer here?
My understanding of his theory of defense is that there's nothing directly connecting his client to the import of the drugs. I think he talked thoroughly about how there's evidence that someone went to Jamaica. We don't know who the third person who provided Delano Brooks with the drugs was. We don't know who that person is. We have him going to pick up the drugs. We have nothing showing that he was engaged in the sale of drugs, no baggies, no
Well, your
scales.
client admitted that he talked to Mr. Brooks and said, can you get me hot cocoa?
Yes.
There must be some really good hot cocoa. I mean, last I checked, we actually have hot cocoa here in the United States, but let's assume that this is really good hot cocoa and he wanted it from Jamaica. Let's assume that. His theory was, in summation, the lawyer was, Mr. Brooks is the guilty party. Mr. Brooks, who self-reported, he walks into the police department with 3 pounds of cocaine worth $60,000. And there was no suspicion. Nobody suspected him. He got through customs. I mean, he was home free. And defense lawyer's theory in the summation was Brooks is the guy and he's just pointing the finger at the defendant, which, as the prosecutor said, if that's true, Brooks is the stupidest drug dealer in a history of drug dealing. I mean, he already got the drugs in. He's just going to go and give them to the police. And so that was the theory the defense lawyer rolled with at trial to the jury. I don't know. That doesn't speak well of his performance.
And Your Honor, this is not a case where we admit everything was perfect. There were multiple errors. But I think when viewing the totality of the circumstances, he was able to attempt to point blame to someone else. He was able to thoroughly cross-examine on the evidence, despite allegedly having not reviewed it in its entirety. He was able to launch objections into evidentiary issues for the Kamisha Reed texts. He was able to object to it as beyond the scope of the Molyneux application. He was familiar with the evidentiary admissions and rulings of the court. He was able to object to the admission of the Watson memo or voice memos as beyond or lacking foundation. He was able to pull out that the investigator did not know that that was his client's voice, that it was coming from his cell phone number, but it was not necessarily his client's voice. So I think, yes, there were some flaws, but I think viewing his performance in totality, it was not a fatal flaw that denied him his due process rights. And if there are no further questions on my remaining points, I'll rest on papers. Thank you.
Thank you. It's 9:06, the People versus Flowers.
Justice Lindley, you may please the court. As the people can see, there were 170 days of pre-readiness, pre-certificate of compliance, 30-30 delay. The Supreme Court erred, however, in determining that there was not at least 13 days of post-readiness delay based upon the people's failure to obtain and turn over the grand jury minutes in this case until at least 4 months, approximately 4 months after the case was presented to the grand jury, and 35 days after the extended time to provide the grand jury minutes had expired. More to the point, the Supreme Court erred in determining that The people's papers demonstrated that the people had exercised due diligence to obtain and turn over the grand jury minutes throughout the period at issue.
Counselor, let me start first with the filing of the initial COC. You don't disagree that at that time, the people exercised due diligence and made reasonable inquiries?
That's correct. At that point in time, obviously, they could not have provided the
They
grand
could,
jury
and
minutes.
so at that point, you agree the clock stopped.
That's correct. So what is at issue?
Right, your argument depends on us restarting the clock at a certain point.
That's correct. And I know there's a recent decision by this court, People versus Walker, where there was a concurring opinion by Justice Curran, where he expresses the view that where there's a proper certificate of compliance that exists, and then the people fail to exercise due diligence thereafter to turn over the discovery, that does not create
A 30-30 issue.
that does not create post-readiness delay.
So if that,
However, that argument was not raised below and is not being argued by the people here, so
Right.
thus
And that-
it's not reviewable by this
Well,
court.
And the Walker concurrence from Justice Curran, it's distinguishable here because those were disciplinary records from the parole division, which the panel in Walker determined were outside the possession of the people.
That's
This,
correct.
by definition, under 245-20 sub 1, the grand jury minutes are in the possession of the people. So that addresses the concurrence in Walker. But the other case that Judge Curran was on that you mentioned in your brief is Gear.
Mhm.
Gear was one of the first discovery cases we've had. It was February of this year. And I did a deep dive on Gear. I wasn't on it, but tell me if you think my reading of Gear is correct. Is that what that panel was saying in Gear is that if the people file a certificate of compliance and they check the box saying, we provided everything but the grand jury transcripts because they aren't in yet through the delays in transcribing them. That's a valid COC, regardless of what happens later. As if there's a delay in the people turning it over, grand jury minutes in there was a long delay, like 9-10 months maybe. In Gear's view, it doesn't matter. Once you have a valid COC, any mistakes falling down on the job with respect to grand jury minutes subsequently does not vitiate that statement of readiness in COC. That's how I read Gear. And I'm not, you're free to say, of course, with all due respect, that Gear, we got it wrong. But am I reading Gear right in your view?
Yeah, my understanding of Gear is that the people provided the grand jury minutes within the extended time allotted by 245-20. So 30 days after arraignment on the indictment, plus an additional 35 days thereafter. Here, on the other hand, this is well beyond the 35 days. So I don't read Gear as saying that the people can just ignore their responsibilities to exercise due diligence to provide the grand jury minutes without the certificate of compliance becoming improper and there being post-readiness delay. Indeed, the people are not disputing here today, and they didn't dispute below, that the people failed to demonstrate that they exercised due diligence, and for good reason. The people's papers are conclusory as to the steps they took to try to obtain the grand jury minutes, and as to the grand jury stenographer's ability to timely provide them. And then again, unlike Gear, the people failed to provide the grand jury minutes well beyond the extended time to provide them.
Maybe I have the dates wrong in Gear, but I have the Gear. The indictment was filed on February 4th of 21. The COC was filed on February 16th of 21. The grand jury minutes weren't turned over until November of 2021. Those are dates I have.
My recollection, reading the decision, the court indicated that the period was within, that they provided the grand jury minutes within the period allotted, either within the 65 days of indictment or upon
Okay.
you know,
Yeah, if
upon
you're right on that,
245-7,
Yeah, it's either 65 days if he's in custody or 50 days if he's not.
right?
If you're right on that factual situation, the gear is distinguishable. So we'll have to look at that, but I guess your main point in the brief is that the deadline here was 65 days from the arraignment on the indictment. You get 30 because he's out of custody. You get 35 because he's out of custody. You get 30 more almost automatically without asking, without going to good cause.
To 245-20, that's
And then
correct.
They weren't turned over for another 35 days. So you want to charge those 35 days to the people, right?
Unless they can demonstrate that they exercise, that notwithstanding that they exercise due diligence to provide them. And even with the exercise of due diligence, they couldn't have provided them 13 days earlier. And 13 days critical here because there were 170 days of pre-readiness delay. The 13 days would put them beyond the prescribed period. And the fact, and as a matter of fact, as the district attorney stands here today, they don't dispute that the people had failed to exercise due diligence to provide the grand jury material. Instead, they are arguing only that our contention is not preserved for appellate review. And that, of course, is not correct. In Mr.
Counselor, if I may, your position is, let's say it was 65 days after the arraignment, we had another 15 days to tack onto the 170, or 12 days to tack onto the 170. So they had really, in your mind, for speedy trial purposes, 65 days plus the remaining days left from the initial file. Your analysis requires us to make a determination when the district attorney no longer was exercising due diligence or taking reasonable efforts, right? And that would spring the clock to start. We would relate back to the initial filing.
That's our position. Well,
Can you,
based on the allegation made by defense
because
counsel,
just to be clear here,
Yes.
you're not saying that the initial filing was illusory.
that's correct.
This is a springing speedy trial determination that then relates back to the initial filing.
That's
In your
correct.
mind.
That's correct.
Post-readiness delay? Would you describe this as post-readiness delay?
This is a post-readiness complaint, and that is the contention of defense counsel below. And the people don't dispute that the certificate of compliance became improper if they failed to exercise due diligence, nor did the court below determine that the certificate of compliance could not become improper. Instead, the people contended below that they met their burden of demonstrating due diligence, and the courts expressly addressed that question, determining that, yes, Justice.
I'm sorry, Counselor.
No,
There's another lens to look at this, isn't it? That if this initial filing was proper and the clock stopped, then any issues that we have related to discovery after that time should be resolved with discovery sanctions. Right? That it's not necessarily a 30-30 issue down the line, but this is a discovery problem because we could hypothetically, the prosecutor could come into possession of evidence that should be turned over and they delay doing that. Does that then, in your mind, relate back to the initial filing?
This is not an argument that was made by the people below, just to be clear. They didn't argue that the people couldn't become unready if they failed to exercise due diligence to provide new discoverable material, that it didn't result in post-readiness delay. So the position you're suggesting here is not an argument that was raised below, thus is not preserved, and it's not an argument that the people are making here. But that is our position. That is consistent with legislative intent. It has always been the case that post-readiness delay constitutes, delay that's relevant to the 30-30 analysis. And it's further was the legislature's intent to link discovery compliance with 30-30 trial readiness.
The reason I'm asking that question is the motion wasn't to dismiss because of a discovery violation or a sanction. The only issue in front of us is whether or not this is a 30-30 violation.
That's correct.
It could have been a multiple motion and asked for the sanction of dismissal potentially under Article 245, right?
It could have been, but it need not be because legislature is clear that the lack of discovery compliance can render the people unready. It can render the certificate of compliance improper. While there was an initial certificate of compliance that was proper. That certificate of compliance, if proper, is not always a placeholder, that the people have a continuing obligation to exercise due diligence. And that was the intent of the legislature. Here was to connect discovery compliance with 3030 trial readiness. And so that is our position here.
Can I ask you this, though? You said earlier in response to a question from Judge Del Conte, you weren't challenging as illusory the COC filed on April 29th of 2022. The defendant was not arraigned on the indictment until May 3rd.
That was May 16th. I think it was
I'm sorry, you're
indicted
right,
May
sorry.
3rd.
You're right. It was filed on the 3rd, and then he was arraigned on the 16th.
That's correct.
So can you have a valid statement of readiness in COC before the indictment, before the defendant's even arraigned on the indictment? Here, I mean, they were ready for trial before the case even came to court, and the clock started running.
That they can establish their readiness. They can have a valid statement of readiness if they have both properly announced the readiness, as you know. What you can do upon an indictment and pre-arraignment, assuming that it's at least 2 days prior to arraignment that the defendant has been indicted, which I believe was the case here. The indictment was May 3rd and he was arraigned May 16th. So the statement of readiness could be valid. And at the time, I would concede that the certificate of compliance was valid, was proper, I think is the appropriate phrase. It became improper, essentially became improper. There was post-readiness delay when there was a point when they could have provided the grand jury minutes, but did not do so, even with the exercise of due diligence. And I think we're being generous giving them the 65 days because the statute recognizes that people get those 65 days. And the people not only didn't provide the grand jury minutes within that 65-day period, but after it expired, they did not move to extend that time pursuant to 245-70 based upon a showing of good cause. And I would say that that is telling. It means that they could not represent to the court that there was good cause to provide, to withhold the grand jury.
Isn't the law even better than you say for you, in that you don't get the extra 30 days for the asking? Under the statute, it says, quote, if in the exercise of reasonable diligence and due to limited availability of transcriptions resources, the transcript is unavailable for disclosure within the time period of subdivision 1, which is the 20 or 35 days. Then you get the other 35 days. But don't you have to show that you exercise reasonable diligence and there actually was a delay? Like, in other words, you have to say, well, I called over there and they said they're not ready. Why weren't they ready? What's the backlog? Why is the backlog? Do you prioritize?
Yeah.
So there's that reasonable diligence, due diligence, but then there's another one on top of that.
Yes.
Even so, there's 2 levels of due diligence. You're not really arguing that first one. You're kind of giving that because
I'm giving that away because
Yeah.
I'm stuck with the papers below, and
Right.
the defense counsel conceded that you could not reasonably expect the people to have provided the grand jury minutes within that 65 days. of
even though there
arraignment.
was no explanation of diligence there, but
No,
you're
there-
gonna let
there-
that slide.
There was a boilerplate
Yeah.
that grand jurors are grand jury stenographers are busy, but there wasn't a statement from the stenographer.
But it's the second one. The general due diligence requirement that they talk about in Bay is after you, even if you get the extra 30 days, so it gets you 65 for your client. Your brief, as I read it, is the people then need to have some evidentiary proof, affidavit from the prosecutor, from the stenographer of why can't you get them on time? Why can't you get them within a 65-day deadline? Just saying for the prosecutor, I don't have them yet, isn't enough. Then there's a lot of trial court cases that I'm sure that you've seen. And there's a case from that you cite in your brief from the second department, I think, first department, where require some evidentiary showing of reasonable efforts and due diligence with respect to getting them. Here you say they didn't make that proffer.
Obviously, they didn't make that proffer to justify not turning over the grand jury minutes, not at the deadline, but 35 days later. And in order to avoid 30-30 dismissal, the people would have had to show that they, even with the exercise of due diligence, they couldn't have provided the material 13 days sooner. And they didn't do that.
But if my reading of Gear is correct, not to check the dates, it really doesn't matter under Gear. As long as you have a valid COC, no matter how dilatory you are in the grand jury minutes and get into them. And there, I think it was 9 months they sat on. Matter of fact, in Gear, when as soon as months and months later, well after the 65-day deadline, the defense lawyer mentioned, I'm going to bring a motion to dismiss. That very day, the prosecutor goes, oh, here you go. That was Gear. We affirmed in Gear. Not only anyone on this panel was there, but Gear again seemed to suggest it doesn't matter any lack of due diligence, any negligence thereafter doesn't vitiate that COC. That's an interesting decision.
And again, it's my reading of Gear that I can't speak to the dates, but there's language in Gear that says that they were provided within
65.
within the extended period
Yeah,
of
okay.
time. And this was 35 days beyond that. But I can't, unless though you have the opportunity to look at the record, I can only speak to what was said in the decision. I can't speak to the particulars other than that's what the holding of Gear. If I could just make one, I know
Sure.
your court's very busy, but the people contend that that by failing to move to challenge the COC or failing to alert the people or failing to confer with the people about the deficiency in the COC, that somehow defense counsel has waived this 30-30 claim. They didn't preserve that issue below. And in People versus Baker, this court held this is not issue that the court can address for the first time on appeal. And then as to excludable time, the court did not address the question of excludable time. This court must remit to make a determination as to excludable time, but only to the question of post-readiness delay. People didn't argue that any of the 170 days pre-readiness stay was excludable. So this court can't remit for that to resolve that question because the people below did not preserve
Right.
it.
And you got the resulting from issue. It sounded like, and we've seen this argument from Mr. Schiffer many times. Your argument is there were requests for adjournments for motions by the defendant, which would normally be excludable time, but that did the DA's failure to turn over the grand jury minutes did not result from those motions. Had nothing to do with it, so that time should not be excludable for grand jury purposes.
Well, first of all, I don't believe the record shows or the papers allege that there was a request for an adjournment during the period in question. There was not a request nor did the defense expressly consent to it, an adjournment. The people did argue in boilerplate fashion that this period is excludable because motions were pending. They did not, however, allege that those motions in any way resulted in the delay at issue here. And that is the delay in providing the grand jury minutes, and nor could they, because that's clearly independent. And if we give the plain meaning to the resulting from language, as the Court of Appeals has done in People versus Sturgis, for example, they couldn't find that period excludable on that basis. You can't find. But again, this court, that issue is not before this court because the court didn't make that determination as to excludability. Any further questions? Thank you, Your Honor.
Thank you. All right, there's a lot there to respond to.
Yes, there is.
Start where you wish.
I'll start with the fact that, yes, the people didn't argue below that the defendant needed to challenge the certificate of compliance. But in order for you to reverse on that issue, what you have to do is you have to make the determination that the defendant never asked for below, right? So in order to reverse on that issue, you're going to have to decide that supplemental certificate of compliance wasn't filed with due diligence. That explanation that was provided in the supplemental certificate of compliance was not valid. That went unchallenged, right? So when you talk about the orderly procedure of things, yes, it is true that the legislature has linked 245 and 3030 together, but it is also equally true that the legislature has said that in order to challenge a certificate of compliance, you have to challenge it as soon as practicable. Here, there was no challenge. There was no challenge at all to the, and as I think you pointed out, Justice Alcanti, this could have been a combination motion, right? And the defendant could have explained why he delayed in challenging the certificate of compliance and moved pursuant to CPL 245 to invalidate the certificate of compliance. He didn't do that. So when he doesn't do that,
Well, I'm sorry if I can. Sorry to interrupt you.
you can always.
But I don't read their challenges attacking the initial filing.
Correct.
So they say that's perfectly valid.
Yes.
The problem we have is down the line because we're going to tack on another 15 days or 25 days to the initial
That's
on readiness time.
that's true, but you
Which-
also,
so-
oh, sorry.
Right.
No.
So just to be clear here, as you're arguing it, they're arguing that the clock starts again at some point down the line because there wasn't a supplemental COC filed at the right stage.
It's down the line. See, it's not only is the defense obligation to challenge initial certificate of compliance within as soon as practicable. They also have to challenge any supplemental certificate of compliance as soon as practicable, because a supplemental certificate of compliance could be invalid for whatever reason, or in this case, the reason because the grand jury minutes hadn't been turned over in a timely fashion. He didn't challenge that. And what you had as a result is a unchallenged supplemental certificate of compliance. The explanation provided for in that supplemental certificate of compliance went unchallenged for an inexcusable period of time as a result. And because of that, that is the reason why when you look at it as just a straight 30-30 motion, did the people declare readiness with the initial certificate of compliance? Yes. Right. Did they continue to be ready? Yes. Was there any post-readiness delay? No. Why? Because the explanation provided for in the supplemental certificate of compliance was deemed valid because the defendant never challenged it. So not only did he have an obligation under the discovery statute to challenge it, he also had an obligation under the court's order to challenge it because the court issued a discovery order, which said that any challenges to CFC are waived. Here, what you're being asked to do is to find that the defendant, it was entitled to 30-30 dismissal, not because there was independently 100 and I think it's 82 days of time that was chargeable to the people, but actually because of that supplemental certificate of compliance not being valid, that explanation not being sufficient. And in order to do that, you basically challenging, it's an end around the procedures that are required under CPL 245-50 and the court's order that ordered that the defendant challenge the supplemental certificate of compliance.
So under your scenario, when do you challenge the additional period of non-readiness?
In terms of the supplement, when the supplemental is filed,
Right.
the statute says as soon as practical. Now, if you accept what the defense is saying, right, that explanation was insufficient, there was nothing that was required of the defense attorney to sort of look at sort of voluminous discovery to determine whether it had all been provided. So that practicable would have been, I won't say immediately, but within a sufficient period of time. And this was not practicable. This was like, there was an extended period of time, I believe it was 6 months, from when that supplemental certificate of compliance was filed to when the motion was ultimately filed. It's basically sandbagging. That's what they did.
So as I understand the defense argument here is that the people have a responsibility to redeclare their readiness at the end of that 65 days post arraignment. If they have to file that COC, that supplemental COC, I'm sorry, along with turning over the grand jury testimony, or otherwise they've got to explain it.
Although it's the second part. It's the otherwise they have to explain.
They have to that if so to find for the defendant here, there's an automatic, we would essentially be finding an automatic restarting of the speedy trial clock at the end of that 65-day period as it relates to the failure to turn over the grand jury testimony for some reason. And the people would have an obligation at the outset to come forward and get an extension of time or make some kind of explanation. Alternatively, the failure to turn over that grand jury testimony is a discovery issue
Yes,
to be resolved with a discovery motion and potentially sanctions and maybe even dismissal if it's egregious enough.
absolutely. And
Right,
that
so-
may come up, I'm sorry.
So that's what we have to deal with, right? The interplay of these two.
Yeah.
But that's not here in front of us now. There isn't a request to sanction the people
No,
for failure to turn over the grand jury.
because they didn't use the procedures. I mean, you're talking about the adequacy of the explanation. I'm not up here defending the adequacy of the explanation because I don't believe that the adequacy of the explanation was ever properly put in dispute in this
Right,
case.
it's just a question of who has to go first on that, of the adequacy. When the defendant says, I don't have him, I don't have them, it's more than 65 days. You're saying they have to explain, that they have to allege your explanation is unsatisfactory, but they don't know what it is until you proffer it. Like, doesn't the prosecutor have to say,
No, well,
yeah, we're beyond 65 days. This is why we've got so many indictments and our grand jury stenographers are overwhelmed. I guess it is who has to
No,
go
yeah.
first.
No, and just to be clear, his obligation isn't to say, at that point, I don't know what your explanation is. All he has to do is say, it's been 65 days, I don't have the grand jury minutes. That's it. That would be his burden in that scenario and challenging the supplemental certificate of compliance. Or to make a discovery motion generally, right? But when you
Didn't
get
they
to the
do
supplemental
that?
certificate of compliance,
But didn't that happen here? I mean, albeit not on 66th day, but it happened eventually.
It happened-
35 days later.
what's that?
It happened 35 days later or sometime thereafter, right?
That he got the minutes.
Yeah.
Yeah, but there was never a motion, there was never a discovery motion. There was never a motion to challenge supplemental certificate of compliance. And then I go back to there was an argument a few months back, and I believe the court just decided the case that they were discussing speedy trial, this concept of speedy trial in the context of a murder. And the court had said, well, of course, it's not available because speedy trial doesn't apply to murder. And it was pointed out in that decision that there were other remedies for discovery violation, right? The thing to always remember is there are two analyses that the court should do. Is the court going to analyze something as a result of a discovery issue or a speedy trial issue? It's possible that the court can do both because what can happen is the defendant challenges a certificate of compliance or a supplemental certificate of compliance and couples that with a 30-30 motion, right? You can do both at that time. But here, that didn't happen. The certificate of compliance, the original one, was valid. The supplemental one was never challenged. That explanation was never challenged in a timely way. So as a result, when the court's deciding that motion, what it's doing is deciding that motion in the face of what was otherwise an unchallenged certificate of compliance. And because the court had issued a discovery order saying that these challenges needed to be raised or they were waived, this is in essence a discovery challenge. It's not a speedy trial, right? Because
Can I ask you this last question for me at least?
Sure.
You didn't mention Gear in your brief, Mr. Dubrin did. Is it that you agree with him it's distinguishable factually?
no, I just hate to say it, but I missed it.
Okay.
I really
Well,
did,
you know,
and-
you got a million cases. That's understandable.
Yeah.
But so I'm sure you looked at Gear.
I've looked at
Are
Gear,
you
yeah.
relying on Gear as dictating the result here?
I don't know in Gear whether this particular question was posed, but when you look at Gear, right? If I have Gear in my pocket, then I win, period, regardless of anything else. I think you can reconcile Gear with what I'm arguing in the sense of, because I believe Gear was it may have been pre-amendment to 24550, where there wasn't the ability, there wasn't the requirement, the obligation of the defense attorney to challenge.
Yeah, it was
compliance.
either unpreserved or before that the statute
Yeah.
was amended.
So here, right, now you have that obligation, right?
But nobody argued waiver here though, right?
I'm sorry?
You're making the argument now that they should have brought this motion sooner, but nobody argued that below.
No one argued that below, but the point is, You're being asked to make a determination on a record that wasn't developed. You're going to say that that explanation was inadequate. Or I'm sorry, the defense attorney is asking you to decide that that explanation was inadequate. The record is what it is because the defense attorney didn't challenge, he didn't use the proper procedures to challenge that explanation. So in the face of the fact there was no challenge to that explanation, and this is basically what the supplemental certificate of compliance boils down to, is that explanation valid or not? If it wasn't, then the defense attorney should have moved and challenged that supplemental certificate of compliance, right? All he had to do is say they exceeded the 65 days, right? And this explanation was inadequate. And if the prosecutor didn't come up with an explanation, then the court could have struck the supplemental certificate of compliance. It could have issued, it could have made a decision at that time was chargeable, right? And then the defense could have used that ruling to make a 30-30 motion, which he would have won. But he didn't do that. So he's asking you to do that work now. And that's my point with the fact that, yeah, that wasn't argued below, but in order to decide this, you're going to have to make that decision that that supplemental certificate of compliance was invalid. And that never happened. So that's what the court is faced with. The record is what it is because the defense made the record. There are no other questions? Thank you. Thank you.
Case 908 is People versus Dontavius Gordon. 908.
Good morning, Your Honors. Alexander Prieto on behalf of the defendant and appellant, Mr. Gordon. I'd like to focus today on whether the weight of the evidence supports liability on an accomplice liability theory. The people have also argued for principal liability, but I've covered in my brief the reasons why I say that's very weak. As for accomplice liability, there's no question that Mr. Gordon was hanging out with 3 people who also robbed a 4th person that he was hanging out with. The question for accomplice liability purposes is whether the evidence establishes that Mr. Gordon shared those 3 people's intent to forcibly take property from the 4th person.
So you acknowledge that your client was present. He acknowledges that, but presence alone is not enough. You acknowledge he drove the actual people who participated in the robbery to and from the robbery scene. He delivered the victim, his good friend, to and from the robbery scene. So there's aiding and abetting there, but that may not be enough because he has to share the intent. I mean, they could have just formed this while they were there smoking marijuana. And we need to look at whether there's enough it doesn't look like from that video, it's a little hard to say whether he actively involved himself in the robbery. I know the victim said he did. I couldn't really tell from the video one way or another, but the people are going to get up here and say, well, he doesn't have to actively participate as a principal. He's an accessory because of all these things he did to help. And his intent can be reflective of when your client asked the defendant why this was going on. He made some comments about, well, it's because of your sister and wouldn't give him things back, wouldn't give him the keys to the house. And so there's some testimony there of your client's role and statements during the course and commission of the robbery, right? That's really what this turns on.
Yeah, I'd like to go ahead and address those statements, the trial testimony of Mr. Rosario about things he attributes to Mr. Gordon during the robbery. And, I'd start off, those things are right. They're not things that are corroborated by the video. The video doesn't show him holding property in his hands. It does show them exchanging words at I think about 2 points. It shows them exchanging words, but there's no sound. So we don't know what words were exchanged. And there's 2 things I'd like to emphasize about these uncorroborated, what I'll call the uncorroborated aspects of Mr. Rosario's trial testimony. First, as far as the statements, they definitely expressed some hostility towards Mr. towards Mr. Rosario, the victim. But they don't, I would submit, point clearly to intent. It's important to remember that the video shows them exchanging words after the other three have already taken property from Mr. Rosario. So those statements don't necessarily say anything about what Mr. Gordon knew or intended before it happened. I mean, also, and if he was in this situation where all he wanted to do was smoke marijuana with his friends, but then found it transformed into a situation where three of those friends are suddenly robbing another, he's going to be feeling a lot of different emotions, likely. He may be confused, angry, stressed, and it's not all that surprising as a matter of psychology that maybe he's going to blame Mr. Rosario for what's going to go on, and that's going to come out as angry statements or hostile statements toward Mr. Rosario.
Maybe he feared they're going to rob him.
Maybe it's quite, I mean, he might just say, go into a mode, I'm going to protect myself. I'm going to just not get in these folks' way. I think that's a reasonable view of the evidence. The other thing about Mr. Rosario's testimony is it had credibility and reliability problems. I've detailed in my brief the ways in which it was internally inconsistent and also contradicted by the video evidence on not just collateral details, but on central aspects of his account of what happened, like the number of people who went into his pockets or whether a gun was used. Now, since credibility, normally weight of the evidence, the court typically will defer to, of course, the jury's findings. But that principle doesn't come into play here. And that's because we have a factually inconsistent verdict, which makes it really mostly impossible to know what aspects of the victim's testimony the jury credited and which it didn't. The jury acquitted Mr. Gordon of robbery in the second with the assisted by another element. It convicted him of robbery in the third, which doesn't have that element. So it doesn't add up because the evidence is very clear that if Mr. Gordon was involved at all, he didn't act alone. The only thing we can really say with any kind of confidence about what the jury thought is that they didn't find Mr. Rosario's testimony sufficiently credible to take 100% on face value. And we know that because the verdict form indicates that the jury rejected the affirmative defense to robbery in the first without having to determine whether the object that appeared to be a gun really wasn't one. It found that there was no such object. So that's where I argue that the court should come out on Mr. Rosario's testimony. It's problematic and it's not, and the court really can't defer to the jury. It's got to make its own credibility determinations from the record here. So the court, I submit, is left with testimony that's not sufficiently credible and reliable to move the needle on Mr. Gordon's intent. The other point I'd like to talk about is the actions by Mr. Gordon before and after the robbery that the court brought up, inviting Mr. Rosario to come with the others to smoke marijuana, and then driving away with the three perpetrators after the robbery is over. So certainly one can look at that and say one possibility is there was a plan that he was in on, but that's not the only possibility. It's also quite possible, as we said, that he just was with a bad crowd, with the wrong people, because he wanted to, he found himself in the middle of something he didn't plan on. And I think that, maybe the principal objection to that possibility is that, well, is that all that likely? I mean, would the other three really be committing a robbery with someone else present on the scene who might try to stop them? Or who, if he's not in on it, he might try to stop them or he might tell. And, we don't know anything about what the other three people thought as far as what the evidence shows us. We don't really know what the relationship was between them and Mr. Gordon. We know that they were people who were, they were smoking marijuana at 2 a.m. in this parking lot in the middle of the city of Rochester, and they were willing to commit this robbery. They're not necessarily folks that, the decisions might not look, as we're looking at them today, completely rational. But I would submit that if you look at everything together, it's not so improbable. It's not at all much of a stretch to say that, well, maybe They figured, we'll commit this robbery. And they expected that Mr. Gordon wouldn't try to stop them and wouldn't say anything.
And he didn't, and he didn't even check in on his friend.
And not only did he delivered, the defendant delivered the victim to, the place where the crime occurred, delivered him to in the wee hours of the morning to a place which, other people aren't around. And I think it's a very strong inference that there was a reason for it. Okay, and then the jury heard the victim explain why he felt that the defendant was in on it more than just merely being there and providing the conveyance.
Yeah, I'd submit that it's not the only inference. It's not enough. This is to prove beyond the reasonable doubt what Mr. Gordon's role was in this, because he didn't. And I'd urge the court, if there's any questions on how to resolve this case, to take a close look at the video evidence. And the key portions is around 208. He doesn't do anything to satisfy the physical elements of robbery. He doesn't take any actions pointing to intent. In the video, when we see the other three folks converging on Mr. Rosario, there's a fourth person, who everyone agrees is Mr. Gordon, and he's moving around the others out of the way of what's going on into the back seat of the car.
Does Mr. Rosario testify that the defendant also went through his pockets and was in possession of his cell phone, his keys? He had those things in his hand. And he testified, rightly or wrongly, that they all went through his pockets, including your client. This is his friend he's known from third grade, a good friend. The jury believed it, apparently. So how do we get around that testimony? That's active participation as a principal. He went through the pockets, and then he had the stolen goods in his hand and wouldn't turn them back. And then when the defendant said, why is it, the victim says, why this going on? The defendant, as I said, indicated because of your sister whom he had dated.
Yeah. I mean, I'd submit that it's pretty, the video is not the most clear resolution, but it's pretty obvious that the going through the pockets, that's done by the two women. And in fact, that's what Mr. Rosario said the first time when he described what happened. So he's not even consistent himself there. So that pockets directly going through his pockets, I submit that we can rule that out. And we're really looking at accomplice liability. And it's possible, that Mr. Gordon simply didn't help his friend. That's not admirable. Maybe there was obviously some mixed relationships, some friendship and some bad blood, and he didn't help him.
Right. Your argument is not being a hero is not being an accessory.
Exactly. That's the argument. And for that reason, that's why I submit this is a case where it's appropriate for the court to exercise its weight of the evidence review power and conclude that Mr. Gordon's intent wasn't proven beyond a reasonable doubt. The court doesn't have any more questions. I'll end there.
Thank you.
Good morning, Your Honors. Aaron Schwally for the people. I'll start with principal liability. Basically, this is a case where we have a primary set of evidence, which is Mr. Rosario's testimony, and a secondary set, which is the video. I would submit that for principal liability, the primary set, his testimony is more than enough to support this verdict. So the question really is, with respect to principal, does the video so conclusively refute what he testified to as to render his testimony incredible as a matter of law? And I submit that it does not. This is a very grainy video from a distance. It's unclear exactly who was doing what. And what I would submit is during the period that Mr. Rosario testifies to, which is 20901 to 20952, all four people basically went through his pockets. I would submit, and there may have been an error in my brief where I said at 20906, that defendant exited the front passenger seat, walked behind or next to Mr. Rosario and paused. That may have been 20903 as opposed to 20906. But the point stands. During that 51 or 2 second span, he said that all four people went through his pockets. He did walk past him. He was within within a foot from him, and he certainly could have reached into his pockets. It's not clear from the video whether that happened or not, but it's certainly possible. With respect to accessorial liability, this is a case where defendant used his relationship or former friendship with this, with Mr. Rosario to entice his presence in the Durango. He then drove the Durango to a desolate, dimly lit parking lot where 3 people robbed him. He then refused Mr. Rosario's pleas to return his property. And then I think he even said, buzz off. He said, this is because of your sister. That's motive. That's why he was doing this. And then he drove away in what then became the getaway car. So on either theory of liability, and again, we can't know why the jury reached its verdict, but I would submit to this court that on either theory, principal or accessorial, we've got more than enough here. And this, the verdict is not against the law of evidence.
Thank you.
And if the court doesn't have any questions, I'll rest on my root. Thank you.
Case 910. Pinkerton versus Scapone. I'm saying that correctly. Number 910. Family court case. We have. I'm sorry?
Pilkington.
Pilkington, yes. I had you down remote, but you're welcome to join us here today since you're here. Okay.
At any rate, good morning, Jeffrey L. Turner representing a minor child, Samuel Pilkington, who was born on February 25th, 2009. The history here is pretty important, the history of the court's orders. The judgment of divorce was dated March 9th, 2020. That order awarded joint custody of the parties and very close to a 50-50 residency arrangement. Record indicates that at that point, my client was having frustration and anger issues. Intensive therapy for him was ordered. Never happened. Now comes the order of September 21st, 2021. The court awarded mom primary residency, put mom in charge of the child's mental care. And it's clear that the court, at least, was contemplating, excuse me, that the mother would use that authority to consider inpatient therapy for my client. At the same time, that therapy was to address the attachment disorder that my client was found to have with his father. No therapy ever happened. The next pivotal occurrence in this journey was mom's family trip to the Philippines.
It's August of 2022 after the order, right?
That's absolutely after the order.
Yeah, and that's your argument on the change of circumstances. But what it seemed like what the referee Gordon and what the respondent argument is that there's no change in circumstances here because this animosity between your client and the stepfather predated the September 21st, 2021 order from Judge Dollinger. And that relationship was fraught before the order. So nothing's really changed. It sounds like what you're saying, though, is that there is a change because now he absolutely refused to go to his mother's house. That's the difference. Is before he didn't want to go, there was a bad relationship with the stepfather. There was a slapping over an incident with a computer, and there's all sorts of things. There was a prior trip to the Philippines where I don't even think your client went. So there was clearly animosity. There were clearly behavioral problems between the stepfather, the mother, and the son. But so what's the change here? Is the change just now it's gone from I really don't want to go to I absolutely refuse to go? Is that what it is?
It is, and I think if the court will review the record of mom's testimony, the period from January of 22 to August of 22, everyone describes as a time of a great relationship between mom and her son. Things were going great for them. I mean, there was still the attachment disorder because mom didn't dare go to the Philippines to visit her family without taking her ex-husband along, which kinds of a strange circumstance.
Well, it was strange because the child seemed to need comfort.
Right.
But he wouldn't go without his dad, which is a little odd.
But that cries out for what can we do to help this child into a more normal relationship with his mother and his mother's family. You're right. To change the circumstances was the fact that while at some point in the relationship, there was difficulty between mom, stepdad, and my client.
It just got worse. But Referee Gordon, I think, cited cases for the proposition that a child's refusal to comply with visitation is not a sufficient change of circumstances. And you had animosity there before between everybody on both sides. And now the kid just saying, I'm not going at all. Judge Gordon's view legally, I'm not saying she's right, but she's saying that alone, the kid's refusal now, I'm not ever going over there. You can't tell me to go over, I won't abide by the order. That's not enough under the law. You disagree with it?
I respectfully disagree with that.
Yeah.
I think there are cases that say exactly the opposite at the appellate division. A child's refusal to visit is a change in circumstances. Mom has argued, at least in this case, and I think in others, that there was parental alienation occurring. I think she's probably
found that.
Huh?
Judge Dolores seemed to find that in a prior order. That
Right.
decision
I don't disagree with her. I think there was parental alienation going on
by the father.
But my difference with the court below is that you've got parental alienation by the father. You've got a child who's refusing to visit his mother. I think the appropriate step then would be to fashion a remedy where my client, at least temporarily, lives with his father to take some of the pressure off him. Get that child the help that two previous orders felt that he needed. Then move this family to therapeutic counseling.
Yeah, that's a reasonable argument.
Do you have standing on behalf of this child to
I do.
even make this
I do.
address that?
I'm sorry?
How do you have standing if neither parent is appealing the decision?
I have standing as the child's attorney. The child has the right to direct me to take an appeal.
It sounds like getting back to the other point, and standing, we have a lot of cases on it, and I will say, I agree, Justice Akin, we struggle with that, and it's kind of close. Number of cases, I'm not gonna go through them now, but that is something we're gonna look at. We have found lack of standing where the AFC appeals and one party wants to live with a parent who has abandoned any demand for custody. We don't have any indication that the father has abandoned anything, but one thing you said, and I give you credit for the frankness, is that there was alienation, you admit it. So I think what Referee Gordon is concerned about, and maybe members of the panel, is the kid says, I'm never going to the mother's, I don't care what you tell me to do, Judge. There's alienation by the father to get that viewpoint. So do we, Referee Gordon didn't want to reward the father by giving him the benefits of his alienation. And that's what you're asking us to do now, right?
There's actually a case directly on point that speaks to the proposition that even in the case of parental alienation, you should not punish the child.
Right, I saw that, yeah.
And that's where we are. I understand referee Gordon's point of view, but in making the decision she made, she has left my client in a situation where he's probably not doing something that is in his best interest.
Right, but again, just to play devil's advocate, if the reason he believes that way is because he's been alienated by his father, then remaining with the father is going to continue that. There's going to be no hope for rapprochement with the child and the mother because he's with the person who's created the problem.
I understand. But I think your Honor is ignoring the fact that no matter what referee Gordon said, this child was not moving from dad's. It wasn't going to happen.
Right.
So what do? Just wash your hands of it, walk away, leave the child where he is, where he will never have a normal relationship with mom, will never have a normal relationship with his half-sister. The only hope here was for this court, the court below, to order and follow up on and insist that there be therapy for my client, even if that therapy had to be
Right. No, you
inpatient.
make that point very well in your brief. And this is a tough case. I'm not going to lie. I mean, this is really, I see both sides. It's a very difficult situation where you have a child, and all of us who have practiced matrimony and family court have seen some of these cases where a child unreasonably refuses to visit one parent. And what do? Are we going to have the police go to the house and drag him over to the mother's house in handcuffs, probably? But on the other hand, if you don't, you're rewarding alienation. So that's the catch-22 here. Just factually, there was a long time when the child refused to go into the order. Is that still the case? When was the last time the child actually saw his mother?
As far as I know, he's not seeing his mother
For years now.
at least since the decision.
So we're going back almost, a
Mom
couple
can
years.
tell us, yeah.
No visitation at all with his
Right.
mother.
Well, or literally no visitation.
So what we do here
Excuse me.
is not going to really have any effect. We have an order telling the kid he's got to go see his mother. It's been 2 years. He refuses. So if we affirm, he's not going to go see his mother, right?
However, if the court orders and then mom follows up on brings violation petitions, whatever she needs to do to get that child into counseling, to somehow sever this attachment disorder, that's the only chance.
And that hasn't happened.
No, it's not happening.
I mean, since this order, that hasn't happened. There haven't been family court petitions seeking
Nothing.
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 He's going to be 16 in March.
He's going to be 16.
He's gonna be a junior in high school or sophomore.
Yeah. So
In 2 years, this is.
I understand.
Was the alienation that we were speaking of ever the subject of a hearing and expert testimony discussing that issue?
No, alienation was not.
I thought Dr. Carone.
Well, yeah, but that was never in evidence or ever anywhere.
Well, I thought Carone made that finding and then Judge Dowler made the finding.
No, that was never in any legal document. Mom has alleged that, but there's nothing in the record that would support that.
But there's no hearing, there's no tender of proof that alienation is happening. I mean, that is a psychological finding. I mean, we can say that, but a psychologist is the one who diagnoses that.
Right. No such finding was ever made, but Judge Dollar did find that there was this attachment disorder.
And was that grounded by any expert testimony either?
I am not sure. I never saw the transcript of that trial. And the only reference is in Judge Dollinger's decision.
Right. So what's before us that's not contained in there?
It is in the record below that Judge Dollinger found there to be an attachment disorder.
And alienation. He used the word alienation.
Yes.
My memory is not as good as your Honor's. But for me, it comes down to the fact that something is going on between this child and his father that's not good for the child. It's having far-reaching impacts on mom and his half-sister. And I think something could have been done about it. Maybe too late now, but something could have been done about it. That's the point of the appeal.
Thank you for your service. Miss, how do I pronounce your last name?
Scipion, Your Honor.
Scipione?
Yes.
Thank you.
Good morning, Your Honors. Thank you for this opportunity. My name is Dr. Thea Sofia Panilago Scipio. I am the mother of Samuel James Pilkington. He was born on February 25, 2009. Sorry, I'm just so nervous. I am here asking the court to please uphold the judgment of Honorable Julie Gordon from 2023 and to keep the custody and visitation the same because it is the best interest of my son. And Mr. Turner is right. There is a big history into this case. However, as I reviewed the transcript, I noticed a crucial document that was missing. It was admitted into court during the 2022 trial, the judgment of the decision of Honorable Richard Dollinger, a 22-page decision. And this 22-page decision actually described everything of what had happened during that time, from alienation to my son's behavior to the therapists that I have seek treatment help from.
Is there expert testimony from a Dr. Coron,
Yes.
C-O-R-O-N, who did find alienation?
Yes.
Is that right?
Yes, there was an expert testimony.
Testimony meaning he came into court and gave
Yes.
testimony. Okay.
Yes, Your Honor. There was Dr. Coron, and actually I seek a lot of help from CPS. They have their own treatment community help that would actually come to our house. My son also had Khadijah Tillman. She was also the private counselor of my son at that time, and she was also part of the witness during the Judge Dollinger trial. So both of those experts said that I was alienated from my son. So at this time, this is actually when it was remarkably my relationship and with my son plummeted. My son would run away in the morning for no reason, smashed the computer at midnight from coming from the dad, calling me names. Father would interfere with my conversation with my son, sending me nasty text messages.
Yeah, look, I've read all those text messages and the emails, and they support your claim.
Yeah.
And I would think one of the reasons Judge Gordon or Referee Gordon awarded you primary residence with anyone who's going to adopt that attitude, parent toward another parent, should not have primary physical residence.
Yes, Your Honor.
But when was the last time you actually saw your son?
Saturday, I went to see his wrestling.
Okay, when did he come to visit though, voluntarily to your house?
Oh, not this week, but the previous week. He would maybe a couple weeks now. He has been coming over to take a shower and change clothes. I am not sure what the circumstances there at Dad's, but that is another reason why I am really standing here because.
But he doesn't come and have dinner or sleep over?
No sleepover lately. But early this year, he was with me. He was with me he was sleeping over early this year, but just the last couple months, he has not been sleeping over, but he has come
So
to see
things have
me.
gotten a little bit better.
I'm sorry, Your Honor.
Things, sounds like, not that it's relevant for our appeal, okay, but things since the order was entered, you hadn't seen him in quite a long time. And, but that's changed in a positive way. Not where you want it to be, but there's some contact and visitation, right?
Yes, Your Honor. I would say more like peaceful. I'm going to describe it as peaceful. There has been no running away. There has been no smashing. but I keep track with school. I keep track with everything really, from health insurance to his appointment to whatever he needs in school, from teacher if they need anything. I keep track of all those. So moving forward, Your Honor, the alienation, as I mentioned, has started way during the before even Honorable Gordon, and it has just continued. Even the enmeshment has continued. Even this is quite and I think my son's attorney instead of my ex-husband's attorney, that I find that somewhat indifferent. But I would not think that a 14-year-old would just think, oh, I'm gonna go for an appeal. That was driven by the dad.
Okay. Counsel, for your son made a point that during these last couple of years under this order, that you've sort of sat on your rights, okay? This son doesn't come over, doesn't spend 50% of the time with you, doesn't stay at your house, et cetera, and yet you haven't brought any proceeding to correct that. And enforce the order that you had before, which gave you primary custody. So then what happens is the child has spent all this time with father. And I'm gonna ask you, why haven't you done that?
I actually did, Your Honor. Together with this case, there are two cases. I actually counted for a contempt of court. I was able to prove that on September of 2022.
So let's start, before you tell us the substance, if you could give us a date.
Yes. So as he said, it was a pivotal change from the Philippines. That was August of 2022. We came back in September of 2022. And then in that month, I was able to capture father saying that you are not going to return here in this house. So as I mentioned, I did bring it to court. There is a contempt of court, and the father was actually charged guilty of contempt of court, in which he was fined up to $5,000, and up to now has not been.
That was
Also,
after, because Julie Gordon, the referee, recommended he be held in contempt. She didn't have authority. She sent it to family court. You're saying the family court then did?
yes, by Honorable Givens.
Okay, but you said just a minute ago, you said something that kind of supported Mr. Turner's argument. You said that the pivotal change was on the Philippines trip.
Oh, no, that was what he mentioned when he mentioned that there was a pivotal change. No, I do not
You
support
don't
that.
concede that that was a pivotal change?
No,
That's
there
more of
was.
the same from before is what your point is.
Yes, it was actually a continuation, but a lesser degree, a continuation of my son's behavior. But not the entire time. We had good time. It was some part there was good time with family.
And didn't he get hurt? He hurt his leg or something and he came to stay with you and.
So that was the dad. That was my ex-husband. So it was not my son. That my ex-husband hurt his leg, and then so when he hurt his leg, my aunt took him to a doctor. So the doctor gave him antibiotics. Now the doctor recommended that he were to go to the hospital to get tetanus shot. My mom is a physician, so he went to my mom on a Sunday evening, and he wanted my mom to write a script for a tetanus shot. But my mom refused because he was not my mom's patient. And just the character of my ex-husband, it is not the easiest. So because of that, my mom was just cautious, and my mom referred my ex-husband to go to the hospital. But he did not like that idea. And because my mom refused, that was when he started saying not good things about my mom, and caused my son to also side on his dad. So, but my son did not get hurt. That was the ex-husband.
Well, the pivotal issue here legally is there a change of circumstances since the entry of Judge Dollinger's order?
Mhm.
And that's what we have to look carefully at.
Yes.
If we agree, Mr. Turner, then there may be a remittal for a best interest determination, or maybe we could make that determination on this record. That's what we'll have to look at.
I understand. So my stand here, Your Honor, is that there's no change of circumstance based on the argument that is brought here to court. Um,
Do you interact with your son now at all?
Yes, I text him regularly because I feel that even if he's far from me, I don't see him as much as I want to. At least I have that connection. I follow up on him, and as I said, I also keep track on his school, and I see if something needs to a little bit of push, then we talk about it.
But is he refusing to follow the order and stay at your house at night, to sleep in your house? Like the court gave you, you're supposed to be the custodian. Is he refusing to follow that order and stay with you?
So yes, Your Honor, it started off with the dad. The dad said that my son is living with him. And so because of that narrative, now my son, it was just out of the blue. It's always out of the blue from the beginning. And then when he said that, then my son follows. So, but that has been.
And does he go to therapy? Does your son go to counseling for the attachment disorder that the court found? Does he go regularly to the counselor?
Good question, Your Honor. I have tried. So in the order that Judge Dollinger wrote, it did say that it was like recommended to go to inpatient therapy. However, I have to consult with the dad. It is not just ultimately my decision because of the cost too. It has to be divided. So when I would go to the dad would brush me off. The dad would say that there is no problem with the child, that I am the problem. So I should be the one to go to therapy. And in history, I would literally bring my son to Khadijah Tillman, the therapist, go to her office, and he would not leave the car. He would not go with me. And then he would only say to me, he would only go with his dad. But then the dad is also not following all the orders, not really following whatever the court has ordered over the years.
And he's never been inpatient at all, has he?
Not after Judge Dollinger's decision. I want to, if it's just my way and not considering the other, I would have.
Thank you very much for coming in.
Thank you, Your Honor. Thank you.
Case 912 is Red Target LLC versus Lane number 1. That's case 912. Good morning. You are Mr. Spasato?
Yes.
You are representing yourself?
Yeah, correct.
Right.
Okay. Basically, I've been in business for like 40 years, never got sued or anything like that. So I don't know all the formalities of how court was supposed to go or anything like that at the time. So I had a commercial lease agreement with this company, Pawnee, and I got an email from the defendant that I owed some debt to them, and I sent a debt validation letter to one of their employees, Tanya Brownham, requesting validation for it that she never answered.
So when you say validation, you're asking him to outline what, lay it out for you.
Well, how this company, acquired the debt. It's a different company than who I had.
But not necessarily you don't owe the money, but you want to know that they have standing.
That they have standing, correct, that they're the holder in due course. Okay, so I didn't get any response to them, and then I sent a conditional acceptance also after I received the notice, I believe, for court. Okay, I answered, in my mind, I answered the person who sent it. Connor, I believe his name was, with a conditional acceptance, again, basically, trying to verify the standing and jurisdiction that they're the holder in due course, and didn't get any response to that either. So in my mind, hey, I don't think they have any standing. So, further papers, documents that were sent to me on January 20th, it stated that they had
I don't mean to interrupt, I just want to try to clarify a little point. You were a leaseholder, correct? You were leasing the property, right?
correct from Pawnee
Right, and you said you've been in business, what, 30 years?
over 30 years. I have
Okay,
40
and it's
years,
like
yeah.
if someone else bought the property, now you have a new person, you got a lease, and they said, you owe me the money.
What's that?
It's like if someone else, let's say hypothetically, let's say if someone else bought the property and now there's a new landlord, make it picture yourself to you. I
Right.
say, hey, now I'm the guy. You gotta pay me the money, and he says, you owe me this money.
Okay.
Okay. Isn't that analogous to what happened here? Someone's telling you that you owe me some money.
Well, anybody just can't come up and say that they own my debt. They have to prove that they owe the debt. So they filed like we're going to go to trial, a notice of readiness to go to trial. And then unbeknownst to me, on March 9th, I got a letter, or there was a letter from the plaintiff stating that they had a conference on March 8th that I was not aware of. I had nothing to do with that conference, and out of that conference, it was decided that they were going to file a notice of default rather than go to trial. So this ex parte communication, is a kind of a violation of my due process. So I showed up on May 18th was the hearing date for the default judgment, I believe. I showed up to court, because, okay, I didn't file any answer, I guess, to the court, but I'm showing up to answer orally, and nobody was there from the plaintiff. And the judge, he adjourned it to June 1st, which, okay, again, I showed up on June 1st to plead my case, and we had oral arguments, and I got an answer, adverse decision against me, which then I filed a motion to vacate the judgment based on there's no proof of standing, because it went from Pawnee to this red target over here, but in the middle there's this cherrywood. I don't even know what cherrywood, how they got involved originally. So there's no chain of title to go from Pawnee to cherrywood.
Sir, that's what I want you to focus on. This is not a consumer debt transaction, like if someone was buying debt, like a credit card debt.
Correct.
This is a lease.
Okay, well, they have to show
Like
some
in a
sort of.
consumer debt transaction, I think that's what you're kind of leaning towards. That's what you have to show chain of.
No,
This is a-
maybe I'm not calling it chain of title, maybe that's the wrong words to use, but they still have to be the holder, there have to be some sort of contract that there's going from one company to another, they have to put some sort of documentation on the record that there is none. Okay, so I filed a motion to dismiss, and then the judge, he cited Peroni and Peroni as the deciding factor for my default adverse decision there, said that.
The fourth department case.
Okay, and then the Peroni and Peroni case that was cited in Peroni and Peroni. Okay, in that case, excuse me a second here, that they
If I can help you, sir, there's two prongs in Peroni. You have to have a reasonable excuse and you have to have a meritorious defense.
right. So in the Peroni and Peroni case, it says no evidence was presented to support their claim. We conclude that he failed to submit any evidence to support his conclusionary allegation. Okay, but in my case, there was evidence that on the record that I asked for debt verification from these companies. It's in the record here.
Did
So,
you ever think about hiring a lawyer?
excuse me?
Did you ever attempt to hire a lawyer?
No, can't really afford one. Okay, so
Did you
because
ever
of,
file an answer to the complaint, some as a complaint?
excuse me?
Do you ever file an answer with the
I
court?
never filed a answer as per, the legal statutes they go by, because I didn't know him at the time.
Right, so
Okay.
That's
So,
one of the problems here. Right, you
Okay.
gotta,
but
our system is,
Whether-
files, it sues you, you just can't ignore it, you gotta respond, but we understand your issue is that you don't, am I understanding you correctly, that they haven't established that chain of title, they need to show you contracts of purchase and so forth?
correct, they haven't established that the holder in due course is actually,
Is the person you owe money to, because you don't dispute that you owe money.
what's that?
You don't dispute that you owe the money to the original
I didn't
landlord.
dispute that I owed Pawnee any money. I didn't
Right.
dispute that.
Right, so you're just saying, okay, I'm gonna get out of this because Pawnee sold to somebody, and I don't owe this new somebody the money, right? That's essentially your defense?
Well, they haven't proved that they are the holder of
Right,
that.
right, okay.
Okay, and then because they cited Peroni and Peroni for my default, there was evidence on the record of why I didn't show up, because I sent a letter to the company basically to say, hey, can you validate this debt somehow that you are the holder in due course? So the site of that case is an error, fatal error, in my opinion, okay, for the default. So because they haven't proven any standing from the very beginning, that the case should have never been brought forward. I shouldn't even be here right now because the plaintiff didn't have standing, or they haven't proven that they were the holder in due course to have the case to begin with.
Yeah, so your standing issue seems to go to the merits. The other prong to get a default vacated is a reasonable excuse for failing to answer. And your reasonable excuse was what?
That they didn't verify the debt, that this company didn't verify that they own the debt.
Right, that kind of bleeds into the merits though, but like, why wouldn't you have filed an answer raising that contention?
I did.
You did file an answer timely?
Well, I didn't file an answer paperwork, okay, but I did show up in court to give an oral argument, which I stated in court that they haven't validated the debt, that they ever had any standing to bring the case to begin with.
Are you still in that leased area? Do you still lease the property?
No.
All right, so it's not something that's been ongoing. You're out of there.
Basically, yeah.
Well, it doesn't sound very convincing. I mean, either you are or you aren't.
After your dispute about the money, okay, did you then leave the leasehold at some point? Like, has the debt been ended? It's these many months I didn't pay and I owe somebody, but I don't think I owe Red Target.
Well, there's a lot of things that happened in between. There's, we have, government involved with, shutting down my business, along with COVID that, happened, that I wasn't able to do business. My business got shut down, and, I think pretty much all the businesses, including, these companies here, got reimbursed for any debt that was not paid at that time. The government bailed out these companies and gave them money because they lost money for their business.
You didn't get PPP bailout money?
No.
Okay. All right, but we understand your point, and you've written a nice brief, and we have the record. We are going to look extremely carefully at all these arguments. We promise you that.
Okay, well, yeah, like I said, they had an ex parte meeting that directly right after that, out of that meeting that was on March 8th, that March 9th, all of a sudden they're changing their course from going to trial to this, to a default judgment. So how did that even come about? I was never even clued in on this meeting conference.
Right.
So that's a violation of my due process right then and there. That it can't do that. I have to have notification of all conferences pertaining to this case. I have to have notification of it.
Did you file any appearance before then?
Excuse me?
Did they even know you were going to contest this when they had these, what you say, pro se conferences?
I don't know what they thought. I mean, I answered, with a letter to them.
Okay.
So I responded to them. Let's just say I did respond. Okay, when they sent me the case. So it's not like they didn't hear from me.
Right.
I responded.
But not a
So,
formal answer, but we'll take a look at that, okay?
okay. Like I say, the main thing is they haven't proven that they're the holder in due course, that they even have standing to bring the case forward.
Gotcha.
That's the key issue right there,
Right.
that they have to prove that they have standing, and there's nothing on the record that shows that.
I have one more question.
Sure.
Has anybody else tried to collect this debt, either the first entity you mentioned or the second one? Has anybody else said, hey, you pay me the money?
So anybody else try to collect the debt?
Yeah, I'm just wondering if perhaps, that might answer the question about whether they have standing. Somebody else said, sir, you owe me the money, then, there might.
No, nobody else has come, except these people.
Thank you, sir, for coming in.
Okay, thank you.
We turn now to case 913 Otero versus Rochester Broadway Theater League.
Good morning. Good day, I suppose. May it please the court, I'm David Sealing on behalf of Ann Otero. I'll keep my comments brief. The crux of our argument is that the moment the respondent introduced the parking agreement, they conceded the issue that there was a duty by reason of the easement agreement. Otherwise, there would be nothing to delegate by way of that agreement. The way that agreement was introduced below and relied upon, it was a dispositive factor in the order appealed from, deprived the appellant of any opportunity to respond, be it to the applicability, the ambiguity of that agreement. She had no opportunity because it was
It's a new theory raised for the first time in reply, which in your view is improper. Correct. The idea, they move for summary judgment, RBTL, on we have no involvement in this property. We don't own it. We don't use it. We have nothing to do with it.
Correct.
Then in response, you raise an issue of fact, to say the least. You came in with that easement agreement, which clearly contradicted their claim that they had no involvement in the property. So if we stop there, you win, at least on an issue of fact. In reply, they come in with this whole new theory. Okay, we do have involvement. Despite what we said at the beginning, all of a sudden we do have involvement, but we don't have to maintain it because look, we got this private agreement that nobody knew about that the other entity has to maintain the parking lot. You say that's a whole new theory and that that's improper. The court, though, went on to address the merits of the duty issue. The court said, relying on the Sparklet agreement, on the merits of that, to say RBTL contracted with this LLC, Mr. Saki's LLC, and Saki had agreed that he would maintain it. So we all of a sudden now owe no duty of care to the plaintiff. You disagree with that, I assume.
Yes, Your Honor.
But do we need to get that far? If we agree with your point one on the procedural grounds, do we just remit?
Yes, Your Honor.
And ignore the second issue?
The second of the substance of that agreement?
Yeah.
Certainly.
But if we do that, Judge Cariola relied on the substance of the agreement. She agrees. She cited a miscellaneous case that said, yeah, that parking agreement obviates, vitiates any duty owed from RBTL to your client. So if we just do it on a procedural grounds, we're going to be right back here where we are.
After an opportunity to respond, the parking agreement itself, one of the reasons it wasn't originally discovered likely is because it pertains to a neighboring property actually owned by the respondent at the time. If you look at, I believe it's in page 218 of the record, you can see a diagram which describes the parking spaces subject to that agreement. At the very least, the plaintiff below would have liked an opportunity to respond to that, bring any arguments about the applicability of that agreement.
Maybe it's been amended.
I'm sorry, Your Honor.
Maybe it's been amended since then? Because the parking agreement was from 20 years ago.
Well, since that time, there have been developments.
Could have been amended.
Notably, I noted a case from March of this year, which pertained to for people, entities which purchase each other's property and while they're aware of claims pending. There's certainly been changes. However, the easement is, my understanding would be extinguished by unity of ownership at this point. There's
We
no
want some
easement today.
discovery on that to go into that, but let's say that we were to look at the merits of the issue on whether the parking agreement severed the duty that RBTL would otherwise have to your client. Right? Because without the parking agreement, there's a duty. RBTL had an interest in the land via this easement. That's an interest in the land. And if it weren't for the parking lot agreement, they would have a duty to people who come onto their land, i.e. this parking lot. But what if we agree with you that let's assume the parking agreement applies to the very area where the plaintiff fell? Let's just say it hadn't been modified. Can a party who owes a duty of care to a third party contract away that duty to somebody else? As is, because that's what they're saying. Our BTL saying, yeah, we owe you this duty. We would have, but look, we don't anymore because we contracted with somebody else to maintain the parking lot. Can you do that under the law?
I believe it's common to contract away a duty. However, you can't.
Do you have a case that says that? I mean, and you're arguing against your own position here, but do you have a case that says that?
I would respond. I don't know that our argument is that they have delegated the duty. Our argument would be, even in the absence of a responsive argument, the novel argument that we met our burden on summary judgment on one theory. However, we're going to prevail on a different one, poses immediate problems procedurally.
If I could, I think the presiding justice is saying, does it make a difference? I mean, the defendant here has an interest in the real estate and a duty to your client, correct? That's your
correct.
position. So what difference does it matter if they try to contract that away to someone else? I mean, you might have had a right to sue the other party as well if they assumed a duty, but it doesn't mean that the defendant here doesn't have a duty, does it?
It does not. I mean, the defendant has a duty as a dominant owner.
Or is the parking lot agreement even material here in terms of who had a duty to your client?
Well, the court below thought so, and
Right.
we've appealed that.
Our question is, if we disagree with the trial below on that, why wouldn't we just say that? And agree with you in your brief, you say this is a matter of, that parking lot agreement is just a matter of indemnification between RBTL and Saki in a third party action.
Yes, Your Honor.
There's a case from the Second Circuit that seems to be right on point. Sutera, 86 F 3rd 298, 86 F 3rd 298, which basically says the dominant owner of an easement, you can't contract away a duty of care to another party. If that's the case, you win not only on the procedural grounds, but on the substantive grounds.
I wouldn't argue against that.
Yeah, I wouldn't think you would. Anything further?
Not at all.
All right, thank you.
Good afternoon. May it please the court. Megan Brown on behalf of the respondent, Rochester Broadway Theater League, Inc. I think the first issue here with respect to non-delegable duties is it's undisputed that RBTL did not own the parking lot.
Correct.
So to the extent anyone had a non-delegable duty, it would have been the owner, which was
Wait.
not RBTL.
Justice Del Conte raised the point, though. If you're not an owner, but if you're owner of an easement.
Right. An owner in common, which is what it says in the easement at page
Then,
161.
like if we're neighbors and
Sure.
I own my backyard
Yeah.
and I give you an easement, you can use it too.
Yes.
Okay. With the case law that you cited, that Wolf case from Kissingbridge says, absent agreement, you, as the owner of the dominant easement, have to maintain my backyard, right?
Right.
But if there's an agreement, Wolf says, to the contrary, I have to do it if I agree to do it.
Correct.
Even if I say, okay, you can use my backyard, even though you would have to maintain it, cut the
Yeah.
grass, do everything. If we have an agreement that I do it, then it's on me.
Correct.
That's different than what we have here, because that's just a dispute between the owner of the property and the person to whom he or she gave these easement rights. Who's got to maintain it? This case is different. This case is more like that Sutera case that I discussed from the Second Circuit, where We're talking about a duty to an injured third party. And I think you would agree that if the parking lot agreement didn't exist and there was nothing in reply, RBTL would have a duty to maintain that parking lot
Well-
vis-a-vis the injured plaintiff, right?
I don't know that I would. I think potentially there could be an issue of fact as to that duty, but they're not the owner. I think Mr. Parkhurst, as the COO of the RBTL, met his burden because what he says is still true in the absence of with the easement, without the easement, RBTL didn't own that property, didn't maintain it, didn't make special use of it, didn't
So let
occupy
me
it.
stop you there. No one disagrees that your client didn't own.
Sure.
the title,
Correct.
but you do agree that your client was the dominant holder of that easement.
I don't, I mean, I understand
And you
that
don't
they had an
just
easement.
But you don't disagree that under our common law, if a dominant owner of an easement has a duty to maintain that easement.
Absent an agreement to the contrary, which we have here.
Right, and that's vis-a-vis the agreement would be the easement itself that creates the rights in terms of the case.
The
law to
agreement to the
rely-
contrary is the parking agreement. Because the easement here is an easement in common with Saki, right? Because it's their property, it's their building. And the easement gives patrons of the RBTL access for purposes of complying with the ADA to use the back door, not to use stairs, whatever. And this was not a patron of the RBTL who fell, and this was not the box office. She wasn't going to the box office. She wasn't going to a theater event. This was wholly unrelated to the RBTL, and their easement did not displace any other tenants or the owner or anything else. It was, hey, when you have a show going on or when your box office is open, if your patrons need to cross over the parking lot to get in the back door to comply with the ADA, then they can do so.
It was not.
It's an easement in
exclusive
common.
It was not exclusive easement.
That's correct.
If I may, when the easement was created for the benefit of your client.
Sure.
Your client also assumed some duties to maintain the easement.
No, the easement agreement makes clear there's this shared wall inside, and the RBTL took on some duties to maintain the easement with respect to interior spaces, lobby spaces and wall spaces, but not with respect to they didn't take on a duty to maintain the parking lot. That's nowhere in the easement.
I understand that but that's the natural flow of being the dominant estate in an easement arrangement.
But it was an easement in common, so they both were.
Anytime an easement is created, we have a servant estate and a dominant estate. The dominant estate assumes certain duties in taking that position vis-a-vis the land as an interest in that.
In the absence of an agreement to the contrary, which is what we have in the parking agreement. So the non-delegable duty the owner has, and then the parking agreement basically just solidifies what anyone would expect in a premises case, that the owner has retained the duty that they already had. They're going to take care of cleaning and snowplow and whatever.
But I think what it comes down to, does that parking lot agreement define the duties to maintain the parking lot between RBTL and the Saki LLC? Clearly, yes. If there's a dispute, okay, who's got to shovel this? Who's got to salt it? That agreement says Saki does. The question is, does that bind? Does that eliminate the duty that RBTL would otherwise have to third parties?
I understand.
Wolf and Kissing Bridge, it was not a duty owed to a third party. It was between the holder of the easement and the grantor.
Understood.
Who's got to maintain it?
And I read that Sutera case, and I think in my notes I wrote, brownie face or not good or something. I don't think that case, that's the one that you cited from the second department, Judge.
Oh, you saw that.
I've seen it.
Because that was not terribly good for you.
It's not great for me. I don't love it.
You didn't.
But
you
I
didn't
don't
really
think, I think
share
because,
that in your brief, though, right?
well, I saw it when I was preparing today and it wasn't raised by the
I get-
appellant
okay.
and in
Yeah.
Second Circuit, I don't think it's binding here.
So does that make sense to you? Like if I own a property, like a parking lot, and I contract out with somebody else to maintain, and somebody gets hurt, member of the public comes to my parking lot, I say, oh, you can't sue me. Look, you got to sue because I have a contract with someone else to plow it.
What I think the big distinction here is if you own the parking lot. We don't own the parking lot. We have a right of access, a right of use.
You have
in
an
certain
interest. You have an
occasions.
interest in the parking lot. As Judge Delconte's tried to make the point is
Right.
that ownership is different. You didn't own it. But the case law that we have says if you're the owner of a dominant interest, you do have an interest in the property, and there are duties that flow from that.
Correct.
And
But I
you're-
submit
and you're
that
saying that the parking lot agreement removed those duties.
Because it doesn't change anything with respect to the duty owed by the owner to the
Right.
plaintiff.
But this is a private agreement. The plaintiff had no idea this existed.
But the plaintiff knew who owned the property. I mean, in terms of, and the plaintiff's testimony was that after that someone a representative of Saki had even come into her church before and said, hey, can we get other people to help us with shoveling?
Correct.
He talked to Mr. Saki himself, the record of who owned. So I mean.
But they also knew that there was an easement, that RBTL had the right to use it through the easement. Now, would it have been better to sue both? Yeah. Sue them both and let them fight it out. They sued RBTL, thinking they were the owner, probably in all good faith. You said we're not, no involvement whatsoever. And they say that's a little misleading to say no involvement when you had an easement, but we'll overlook that. But they go to the county clerk's office and they're like, oh my goodness, save the day. We got to get out of jail free card because there's an easement here. The parking lot agreement was supposed to be filed at the clerk's office, right?
I saw that, yes.
And it was not.
And I don't know, why, obviously.
Right. So that's not on them.
Sure.
And then your client gets out of it on a private parking lot agreement that was supposed to be filed and wasn't. I don't know, but it's an interesting legal question, but on the procedure, we may not get to the substance. On the procedure, is this a new theory raised for the first time in reply, this parking lot agreement?
Correct. And my response to that, as I set forth in my brief, is that it's not a new theory because we met our burden with Mr. Parkhurst's initial affidavit, and this parking agreement was merely in response to the easement agreement, and that distinguishes it from the Seafeld case because you don't need the parking agreement to meet the burden. He met the burden through his affidavit. It's not a new theory. It's the same theory. We don't maintain the property.
This is the way I looked at it. Maybe I'm wrong. Your first theory in moving was we have no involvement. That was the word.
Right.
We don't own it. We don't use it. We don't have anything to do. I don't know why you're suing us. Then in reply, it's okay. Yeah, we actually do have an interest. But look, we delegated away our duty to maintain that property in which we have an interest to somebody else. They say that's a whole new theory than your first one.
And I think the reason I'm saying it's not is because the first theory was we had no duty because we didn't own, maintain, use, and then
use
or have anything to do with is what he says in the initial affidavit. And then the reply is we had no duty. Still, this is supported because this parking agreement rebuts what was raised by the easement. Like we didn't need those two documents to meet the initial burden, but since the easement was introduced, we have to respond to that on reply. And here's the response.
No duty. Your reply argument is no duty.
Correct.
So are you then, Counselor, saying we need to look at that reply and rule on this issue, whether or not you had a duty?
I think that
it wouldn't be in your mind, it's not fair enough to just send it back to the court that there's a question of fact as it relates to the opposition papers.
Well, I think if you send it back, I mean, here's to Justice Lindley's point from earlier. If you send it back, we're going to be back here. Okay, fine. We'll take a deposition from Mr. Parker.
You're asking for a ruling on the merits.
I'm asking for an affirmance of this decision that was on the merits because there is no duty.
Okay. Thank you very much. We go to 916 Oswald versus Remish. 916. Counsel for the appellant will be joining us momentarily, and she is here. Ms. Richter?
Yes, good afternoon.
You may begin.
Thank you. May it please the court, Joan Richter on behalf of the defendants appellants. Your Honors, I'm here today to ask that you reverse the lower court's grant of summary judgment on negligence and to reinstate our affirmative defenses. Simply stated, we think that there's enough here to overcome summary judgment, and we think a jury should be able to hear from Mr. Ramesh and to hear his version of the accident and to make their own minds up as to whether or not Mr. Ramesh was negligent or not that day. Mr. Ramesh's testimony was he believed there was a yellow light. And if a jury hears that, they could infer or question why was the plaintiff stopped or sitting at a yellow light. At the very least,
Counselor, can I interrupt you? Is that really what his testimony is? If his testimony was it was a yellow light, I read the deposition that he doesn't remember if it was a yellow light.
I believe his testimony was that he thought it was a yellow light.
Right, but if he says, I don't remember if it was a yellow light, then we really don't have any factual disputes here, do we? We have a motorcycle stopped at a light and he's hit from the rear.
Well, and the plaintiff's testimony was that he believes he was stopped at a red light, but there was no testimony brought out as to what color the light was at the time of the impact. So we think at the very least, there's enough that the jury, even if you found Mr. Ramesh negligent, that the plaintiff's culpable conduct should remain an issue for the jury.
And it's illegal or improper for a car to be stopped at a yellow light. Is that what
Well,
you're telling me?
I don't know if it's illegal or improper necessarily, but we think it's enough the jury should be able to determine whether it was reasonable that he was stopped at a yellow light.
Right.
Rather than proceed.
I mean, it's kind of clear that the defendant was negligent. I mean, even if the light was yellow, you should have seen a motorcycle stopped at a yellow light and you're supposed to stop. I guess you're looking at some contributory negligence there from the driver of the motorcycle, right?
Correct. Alternatively, that's correct.
Yeah. Right. I think we understand that one.
Thank
Anything
you.
further?
Nothing further.
All right. Thank you.
Good afternoon. May it please the court, Aaron Adolph on behalf of the plaintiff respondent. Simply put, the VTL is unequivocal as it relates to the required conduct at a yellow light. A driver may enter under a yellow light, as opposed to what the VTL says with respect to the conduct required under a red light. The driver shall stop at a red light. Irrespective of that, the duty is on, or the burden is on the respondent, or the non-moving party, in this case, when confronted with evidence of a rear end accident, to give evidence that shows a non-negligent excuse for the rear end impact.
Sudden stop, unexpected. Is stopping at a yellow light. Well, let's say it was a green light. Okay, everyone recognizes it's a green light, and the motorcycle driver stopped at a green light inexplicably.
Mm-hmm.
Would Ms. Richter be right that there's an issue of fact that some comparative fault there for just stopping at a green light?
Potentially with respect to a comparative question.
Right.
There would be no question with respect to the negligence of the trailing driver.
I think she conceded that a minute ago. Maybe I'm wrong.
But that's
is it different? Is green different than red? Yellow light?
Is green different than a yellow light?
If the motorcycle was just stopped at a green light for no reason, it gets hit from behind. You're acknowledging maybe that's a plausible case for comparative fault. Here it was a yellow light. So the difference is green to yellow is a distinction?
One point of difference here, Your Honor.
Yeah.
I strongly disagree that there is a yellow light here.
Okay.
And the plaintiff or the defendant, when pressed, was incapable of even maintaining that it was, in his opinion, by his observation, a yellow light.
So if it's a red light, you win going away.
Well, I think we win both ways.
Right. But it's like a slam dunk on red.
It's a slam dunk on red.
You probably lose on green. Yellow.
Even on
went for you, but not as easy as red.
Only if we're talking about the question of whether the lead driver has some comparative.
Right.
Would we lose a motion to strike the affirmative defense for comparative negligence if it was a green light? Yes, I think we would, because the jury would be entitled to handle the question of reasonableness of the lead operator's conduct. Here, however, a couple of things. You have testimony, not just from the plaintiff, that he was stopped at a red light when the impact occurred. He was stopped at a red light. Nobody says the light had transitioned from red to green when he was struck. He was stopped. You have testimony that marries that from the trailing defendant, who says the motorcycle operator was stopped at all times as I was approaching him from the rear. He did not say he thought he was going to continue into the intersection. He said he thought that he was going, the lead motorcycle rider was going to enter the intersection, that he would start from a stop position under a yellow light under that scenario. I can't make sense of it, that a person who has already stopped at a yellow at a large intersection, if no one on the panel is familiar with it, I don't know that it exactly comes out, but this isn't a four-way intersection. I believe there are 6 roads that coalesce into this area. It's wide open, huge. You have an operator of a motorcycle at that intersection who, even giving the yellow light scenario, sees the breadth and width of this intersection with all the vehicles that pass through it, elects that it's more reasonable than not to stop here because the light's about to cycle and, grant to himself the protections of a red light. He gets rear-ended.
It's not a simple two-way intersection. It's sort of two highways entering near the 290 entrance. And so there is a very busy and confusing
Side streets plus driveways for traffic, for
plazas
plazas
right
and
there.
gas stations. It's not a simple intersection. But that, and maybe those are questions for a jury to contend with as questions of fact. The record here is the defendant equivocated when asked, what was the color of the light? He said he thought maybe it was yellow. And then when pressed on the question, he admitted, I do not know.
Or he didn't remember.
Or he didn't remember. And at that time, that's really all that you have. He does remember that there was a vehicle that was stopped. He does remember that he rear-ended the vehicle without any other explanation. The defendant met its burden, the plaintiff met its burden on the motion. And we've seen nothing here on the appeal that in any way undermines basically, the defendant's own testimony. If the court has any other questions, I'd be happy to answer them.
Hearing none, thank you.
Thank you, Your Honor.
Case number 917 is Murray versus NCAA.
Good afternoon, Your Honors. Jerry Walsh for Coach Don Murray. Your Honors, this is not an anti-SLAPP case. Let's start with that. Because there's nothing in my client's intent in bringing this lawsuit to protect his reputation to silence or somehow impact the NCAA's First Amendment rights. So if we stop there, that's the end of the case. Because I don't have to substantiate on a 3211 motion anything beyond it.
Well, it's the end of our argument. The case goes forward.
Yeah, right. I mean, it's the end of the motion. We cited the Sandholm case from Illinois because we thought it was exactly on point. Because it says if the sole purpose has to be to try to affect someone's petition rights. And, Don Murray is a tough guy. He's been coaching wrestling for a long time, but he's not going to scare the NCAA. And they tried to scare him by sending him a letter and saying, look, we're going to come after you for your attorney's fees if you don't give up. But he didn't win all those awards and send Olympians by quitting.
He wants to clear his name of any wrongdoing and.
Yeah, they're calling him a cheater.
He's been a coach for 50 years at the D3 level. But Ms. Brown makes the point, well, he had the chance, so he wants this proceeding to clear his name. She would suggest that he had that opportunity at the proceedings below and he withdrew and he didn't challenge anything at the disciplinary level.
Well, that's not exactly what happened. So what happened was they started along this path called summary disposition. And they all talk and they try to agree on the facts. And so he did participate in that. But there came a point where he said, I don't agree with what you're saying on the facts. And so they stopped that. First it started with this COVID argument with the boys playing ultimate frisbee. He volunteered that one of his young wrestlers, his girlfriend, may have been exposed. He volunteered that, followed all the rules, got everybody quarantined, did everything he was supposed to. They issued a press release. He's banned from campus. People are outraged. They know this guy. He just got honored for 50 years of service. he wins. They do, then they do an investigation and they determine that he didn't do anything wrong.
Your papers sort of indicate some kind of almost a conspiracy between some folks at Brockport and the NCAA against Mr. Murray because they wanted him out, because he's been there forever. He's,
Well,
obviously I could add numbers and put him at a high
Yeah,
number.
the people at Brockport wanted him out. That's true. That's the allegation. And when it was clear that the campus investigation was going to clear him, then Brockport self-reported to the NCAA. And that's when they tried to do this summary disposition. Murray said, wait, I don't agree with what you're doing. I'm out. At that point, NCAA sends a notice of allegations to Murray. And then they withdraw it. If they had proceeded down that path, he would have had all the due process he wanted, could have responded, answered, and did everything else. But instead, he withdrew and he resigned as coach, saying, look, I don't want to do this, but I'm doing it for the betterment of the school, the team, and the students. So he got out of it. Then what happened is they did not proceed with the notice of allegations against him with all rights he'd had. Instead, they, alone with Brockport, did this summary disposition thing. Now, what happened was in October and then December of 2021, they sent through this portal that the NCAA has, electronic secure thing, to his lawyer, who said, we're out of this thing. But the lawyer could not access the documents, nor could Coach Murray. And in those documents, they basically threw him under the bus, and all the penalties were against him. 3-year show cause order, all these other things. He had no knowledge, no idea of this. And then the press release hits in January, and he's, what? And he sees it and he says, well, you didn't respond, so you can't appeal. He said, I didn't respond to what? I was out. I didn't have access to this. That's
Voluntarily, he could, but you
no, he didn't. He when he resigned,
Right.
the only thing they could do with him is proceed with allegations, but they dropped those, and then they went just with the university. But when the university agreed with the NCAA, all the penalties were against him. And so then they said, you can't appeal. He said, well, what do you mean I can't appeal? I didn't even know that you were going to do this. You added all these things that we hadn't even talked about even before I quit. So this isn't an anti-SLAPP case, and he's shown the malice that he has to show, which is a reckless disregard for the truth on the part of the NCAA. They can't just adopt the university's position because there's animosity there from the university.
I have a question.
Sure.
All right, so some notes that I wrote to myself, I just need you to clear this up, and I'll ask Ms. Brown to do the same. So there was a decision of the NCAA finding what precisely?
That his classes that he'd been teaching for 40 years were somehow practices. That
Okay,
go
did
ahead.
he appeal that?
No, they said he couldn't.
And who said he couldn't?
The NCAA.
Okay, said, no, you can't appeal that.
Right.
It's not our practice to allow you to do that.
They're saying he can't appeal it because he didn't respond, but he didn't respond because he wasn't in the portal for them
Because he
to send it to him. He
already
was out.
gone. He resigned. Okay.
And his lawyer couldn't access it.
Okay, so I don't know, something is running around in my mind that could be an Article 78, something like that, where you would contest the ruling of some other
Well,
entity or whatever, but
yeah, they're a weird outfit, the NCAA. They're an
Yeah.
association all over the country. And they're, as I said, this is sort of ass backwards here with the,
Yeah.
I should have said bass backwards, I'm
Right.
sorry.
So it's
You know what I
okay,
meant.
because that's what I'm interested in knowing, that there was a ruling. And did it get appealed? Was there possibility of appeal? Was that appeal waived? And you're saying no, and I'm gonna ask Ms. Brown to address that same
Sure.
scenario, okay?
Yeah.
But before you leave there, so it's the NCAA, it's the university or the college self-reporting to the university of I don't want to say improper, but a practice as opposed to a class. They self-reported that to the NCAA.
Yeah, well, that's because they tried with the COVID with the boys playing Frisbee, that didn't get anywhere. So then in the course of that, they said, oh, well, you've got people in your classes who are doing stuff that are like wrestling. And so it must be like a practice. And the coach in his papers blew that away. But the key fact is there is one rule that among all those papers that they threw at you with the manual, there is one rule, and I'll quote the number of it. It's 17.1 Let me get the right one. 17.021.1D of the bylaws. It says if you have a class and it's not on the university list of classes, from where students can select, and it's not available to everyone in the university, then if you do things in that class, it could be a practice. Well, neither of those conditions apply. Anybody could have enrolled in this class, and anybody did. It's not all wrestlers. There are more wrestlers than not. But what he's doing in those classes is fundamental, basic stuff. Practices are an hour and a half grueling conditions. He's teaching teachers. This is a teachers' college, Brockport State. He's teaching future teachers, future coaches, how to teach and coach. Thank you.
Thank you.
Good afternoon, Megan Brown for the NCAA. I don't know, Justice Bannister, if you want me to start by responding to you, or I can.
I would love that. I'm interested in, was there a decision that was appealable, internally? And did the plaintiff have an opportunity to do that?
So here's the reason did not have an opportunity to appeal. There was a decision. He withdrew from the process. First of all, Coach Murray was represented by counsel throughout the NCAA's process. He was given access to the portal. His attorney responded to the NCAA saying, yeah, thanks, got it. There's another email that says, yeah, we've reviewed their investigative materials. That's all in the record, and it's in my statement of facts with the citations there. So his withdrawal from the process was with eyes wide open. All of the correspondence says, if you don't respond, if you don't participate, you waive your appeal rights. That's all in the correspondence that he received. And the notice of allegations, once he said, okay, I don't agree with the facts, we're not going to do the summary disposition process. That's his right. He didn't say, okay, I don't agree to summary disposition. Now I'll participate in the notice of allegations. He said, I'm out totally. So, I mean, to use a sports analogy, he benches himself and then complains about not getting any playing time. All of these arguments that we've heard this morning or this afternoon, whatever time it is, could have and should have been raised at a hearing before the Committee on Infractions by responding to the notice of allegations that he received. And that starts at page 740 in the record. And then the allegations are spelled out. So to your point, Judge Bannister, I agree. This really, it rings like an Article 78, but it's the NCAA has its own process, and Mr. Murray was fully apprised of the process, willingly participated in it, and then as soon as he didn't like where it was going, withdrew, and now tries to come here to Supreme Court and say, I didn't do what I could have and should have done there, but now I want to do it here. And I think that segues into this. This is an anti-SLAPP suit, and perhaps before the 2020 amendments, maybe it wouldn't have been. I know that the statute was more narrow then, and I think that's the view that the plaintiff has taken in this case. But since the 2020 amendments have very much broadened the anti-SLAPP statute, and they have, covered anything that has to do with public petition and participation. And we're talking about allegations involving student athletes at a public institution, including some allegations related to COVID. Certainly, you can't say that's not an issue of public concern. We've got D3 athletes. Everybody is governed by these NCAA rules that Mr. Murray knew about. There's nothing that's purely private about it, which is the only thing that would take it outside of the anti-SLAPP statute. And it certainly isn't purely private, because here we had penalties imposed on Mr. Murray and against SUNY Brockport. So
what do you make of his reliance on the Sandholm case from Illinois from 2012? He places heavy reliance on that. Is that, but for the amendments that you just talked about to our SLAPP suits, is that why our case is distinguishable, because our laws are distinguishable?
Yes, I think that's exactly right. I think the facts there were more extreme in terms of attacking the coach or the athletic director's reputation and character, the phraseology, or the thing, accusing him of treating his students like dogs or slaves, or I mean, it was far more egregious. So I think factually it's distinguishable, but legally certainly distinguishable, because that 2012 Illinois case relies on a 2007 Illinois statute that is premised on petition and association of the government and free speech. This is not, our statute is much broader than that. And the plaintiff acknowledges that in the opening brief, and cites the breadth of the statute, which is far beyond what the Illinois statute encompasses. And we've cited many, many New York cases, none of which were addressed by the plaintiff either in the court below or here.
It doesn't sound like Sandholm has been cited elsewhere in the United States. Are you aware of, I'm sure you probably looked it up. Is there any similar cases that went that way, or is that just an outlier?
I didn't find anything in searching Sandholm. It was cited once in New York, actually, on a promissory note issue, so it's totally distinguishable. But I didn't find, in following the Sandholm thread, anything that would relate it to this case. And I think the New York cases that we've cited would certainly be the controlling case law here. And I think the 2020 amendments is what, I mean, that's the difference here. We're talking about when it's 2007, 17 years ago in Illinois versus the current state of the law in New York, which is much broader.
Thank you, Ms. Brown.
All right, I'll rely on my brief for the rest of the arguments.
Case 919 and 920, actually, 919 and 920 is GMS 2015-GC34 Commerce Court LLC versus Calamar Construction Management. Mr. Massetti is here for the respondent, and Mr. Castellano is here for the appellant. Counsel, you may proceed.
Good afternoon, Your Honors. May it please the court, Carmine Castellano with the law firm of Hodgson Russ, counsel for appellant Calamar Construction Management, Inc. Your Honors, I'll be very brief. The summary judgment decision should be reversed for three simple and independent reasons. First,
sorry, counsel, can I just make a statement? I neglected. Justice Bannister is recused on this matter, but we have four, so we're going to proceed. Thank you. Sorry.
Understood, Your Honor. The summary judgment decision should be reversed for three simple and independent reasons. First, plaintiff's entire complaint and its entire summary judgment motion, including the sworn testimony submitted therewith, rely entirely on the 2015 leases. The 2015 leases, however, had no force and effect during the time period of Calamar's alleged non-payment. There is a clear question of fact in light of the 2019 lease, which we submitted in opposition to the motion. In fact, as we referenced in our papers, the motion court initially denied plaintiff's summary judgment motion because of this exact issue, but later decided to grant the motion without determining which lease was the operative agreement.
Counselor, can I break this down to organize, at least in my mind? We have the motion for summary judgment, and clearly it's based entirely on the 2015 lease agreement. And you say there's a question of fact. There's a question of fact because you raised a question of fact in opposition.
Correct, Your Honor.
Okay. So if it's clear that the burden shifted, that means that the plaintiff did in the initial motion papers establish all of the necessary elements, let's say for ejectment, meaning that at least on the motion, you admit that if they shifted the burden, they established that they have a right to possession.
Your Honor, I think maybe the issue
this is where I'm confused, because we don't know there's a question of fact until we get to the opposition papers. And then it's only because we look at the opposition papers, well, then we're not sure what lease applies. But at the same time, the court made a determination you haven't complied by paying any rent. Aren't you in default anyways under the 2019 lease?
I would argue we are not, Your Honor. We have not paid basic rent. We have not paid basic rent. We concede that. However, we have never been served with a 10-day notice to cure under the 2019 lease.
So set the cure aside for a moment here. Sure. But if the plaintiff shifted the burden and established that they have a right to immediate possession, then you raise a question of fact. Did you raise a question of fact as to their right to their immediate right to possess the property for failure to pay rent, whatever it might be?
We did, Your Honor. So in order to have an immediate and present right to possession, the commercial landlord would have had to have served the 10-day notice, would have had to properly terminated the notice, and then brought the case.
Let's assume you're wrong on the 10-day notice. Okay, let's assume that non-payment of rent doesn't require a 10-day notice. How did they not shift the burden then under the 2015 leases as it relates to their immediate right to possession of the property?
Well, Your Honor, it was the completely wrong agreement. It had no, all of their rights arise from, they have to arise from an agreement. And the 2015 lease
Right,
was
counsel,
null.
but I think this is a question, and this is, I shared this question. I'm not saying I disagree with you, but this is where I'm struggling, is that if the plaintiff made the initial burden, if the landlord did, and it sounds like you just conceded they did, that they own the property, they thought the 15 lease was the operative lease because that's the only one, it was in effect for 10 years, so it would still be in effect. That's the only one they got through foreclosure. So it was a good faith reliance on the 2015. If they met their burden, then, and they also established they got no rent under that. In opposition, you raise an issue of fact with a 19 lease, but the problem is you admitted that there was no basic rent paid under the 19 lease. I guess you have this whole thing of whether you need 10 days notice. Judge Case disagree with you on that. We have to resolve that one. But your only other way to raise an issue of fact is, well, we paid additional rent, these things the landlord was supposed to pay for, and that justifies our non-payment of basic rent. Is that the issue?
Well, let's back up. I'm not conceding that they have an immediate right to possession in this case. I am not conceding that issue. That is contested. In order to obtain an immediate right to possession, they had to serve, again, we're not talking about the 10-day notice to cure, but I that's my position. And you have to terminate the proper lease before you bring the case. Now here, once we raise the 2019 lease in opposition to the summary judgment motion, plaintiff then served the notice of termination for the 2019 lease while the case is ongoing. And pursuant to the New York law we've cited in our papers, a commercial landlord cannot retroactively correct the default correct the defective notice of termination during the case.
Is your client still in there?
Yes.
Because there was a stay and we got the whole bond issue.
Correct.
Yeah, I don't get, and this isn't a question for you, but I don't get why once the 2009 lease was brought out, there wasn't a motion to amend the complaint.
Or withdraw the case, Your Honor, serve the appropriate notices and proceed correctly. Instead, we went forward, we have this decision, and that's where it is. But that's what I would have done. I would have withdrawn the case once I was aware of the 2019 lease, served the notice to cure, served the notice of termination, and refiled.
Or withdrawn the motion and amend the complaint to rely on the 19 lease. But yeah, so we get your point that they sued on the wrong lease. And they're trying to get judgment on the wrong lease. And so, I mean, I think as I read your brief, they didn't even meet their initial burden. As I read your brief,
That's what I'm saying. I don't want to have any confusion here, Your Honor. I agree with that. You have to bring the correct contract when you file a contract case. I mean, so I disagree that they had an immediate right to possession, and then I conceded, that they met their initial burden. They can't even get out of the gate because they do have the wrong lease.
Right.
And also they have sworn testimony that is the correct lease.
So if they didn't meet their initial burden, we don't even get to your opposition papers. We can ignore them. And that's because, your opposition papers aren't the greatest. It's like, oh no, we have a 2019 lease. We haven't paid any basic rent on that. That's not the strongest issue ever. But if we don't get that far, you win.
Correct.
Okay. And then we do have do you want to be heard on that 10-day notice, whether it applies to other defaults or it's written a little not clearly. There's an or in there and there's disjunctive. And do you want to be heard on that before you sit down?
I do, Your Honor. I agree with you that the language is not written, it's not crystal clear. But the 2015 leases have the same provision, the same 10-day notice provision. And in the record at page 94 is my letter to the plaintiff's demand letter under the 2015 leases. So here, the landlord did serve a notice to cure, a demand notice on the commercial tenant under the 2015 leases for a monetary default, which I responded to in the record at page 94. So while now plaintiff contends that the notice provision in the lease only applies to non-monetary defaults, their actions contradict their convenient argument now, because they did serve a demand on the commercial tenant to cure a monetary default, which I responded to at page 94. And although not a part of the record, NICEF doc number 108 is that notice in the lower court. And again, here, because plaintiff served notice of termination for the 2019 lease after we opposed the motion, we asked for opportunity to put in a surreply. We were denied. So, all of these arguments could have been fleshed out more. But again, I agree. Let's go back to the first point. Without the proper contract, they don't get out of the gate. They don't get out of the gate. So, and again, I want to make that clear, though, that under New York law, you cannot cure a defect in a termination notice after the commencement of an action.
All right, we'll take a close look at that. Anything
Your Honor,
further?
just one very quick point with respect to the undertaking. The language in 5519A6 is clear. You cannot incorporate the past due rent into the undertaking. All of the cases cited by plaintiff are distinguishable because there was a money judgment in all of those cases. All of those cases involved a money judgment. And in this particular case in front of us, there is no money judgment, and you cannot look backwards in calculating the amount of the bond.
That's moot if you win on the.
That's a moot. That's all the way down the line, Your Honor.
Yeah. Okay.
Right.
Yep. All right. Thank you.
Thank you.
Good afternoon, Your Honors. Greg Massetti on behalf of
the first question that
respondent.
It may not be dispositive on the legal issues, but that jumps out is why no motion to amend the complaint once it became clear? Because I think you acknowledge the operative lease is the 2019 lease now. There's more property being rented. They consolidated the 2 suites and everything. And why not just withdraw your motion and bring another one based on the new lease?
We didn't believe there was any need to, Your Honor.
Okay.
There is no factual dispute. The initial motion may have been based on the 2015 leases. The defendant produced the 2019 lease, and we acknowledged that
He hasn't paid under either one, is your point?
Well, yes, and there is no factual dispute. So in other words, from a motion for summary judgment perspective, there was no.
Isn't there a big factual dispute here in the sense that when you request the order to remove the tenant from possession under the ejectment cause of action, that's only suites 100 and 200. So that leaves open the other 5,000 or 6,000 square feet that they're leasing under this. You can't get full relief anyway here.
We did not get full relief.
But that's what you're asking for here. You're not carving out that extra 6,000 square feet of occupied space.
It was, Your Honor, and in orders that will I'm sure be before Your Honors soon enough. There was a motion to conform the pleadings to the evidence that came after. None of this is in the record because this occurred subsequent to. And this order is specifically limited to the property that was at issue in suites 100, 200, that additional 9,000 square feet.
I thought it was 9,433 feet.
That 9,400 square feet.
So, but you're saying there's another order coming?
Yes.
There's another motion.
There's 2 aspects to this, Your Honor. There was the request for ejectment, which I'd like to get to, because I think it was clear that we were entitled to relief on.
Right. We'll let you get to that. We're just trying to get.
As to the motion for summary judgment for liability on the breach of contract claim, we were granted partial summary judgment as to liability. Court said there was a lease, they didn't pay it.
Correct.
There's liability here, but as to damages and which lease and all of that, we're going to decide that later. As to that 9,400 square feet, court said, I can't grant you ejectment now on that, but we'll address that later. So there have been subsequent proceedings in the case where we've been granted ejectment for the remaining portion of that 9,400 space, where we've been granted summary judgment as to the 2019 lease for damages. And there's a hearing, I believe, scheduled in January for one part of the damages issue, which relates to future rent. So there have been ongoing proceedings as it relates to the breach of contract, breach of lease issues.
Is there any concern that those subsequent proceedings and orders are going to render this appeal moot?
They should not render this appeal moot as it relates to the ejectment proceeding, nor should it render moot the determination of
Okay.
liability as
All
to
right.
as that partial summary judgment.
We sidetracked you. You want to get to the ejectment claims.
Well, fundamentally, Your Honor, games. That's what defendants are doing here. We have a tenant in commercial space, hasn't paid rent in 33 months. We're coming up on the 3-year anniversary
$1.25 million now.
of this tenant not paying rent. Correct, Your Honor. The Supreme Court properly granted us the ejectment cause of action, and as part of its determination, made some key findings of fact. Plaintiff is the owner of the subject property. Defendant leased certain property that was part of the premises. Defendant is currently in possession of the property. Defendant has not paid any rent to plaintiff since March of 22. And for the time period of March 22 through August of 23, defendant was obligated to pay rent to plaintiff in an amount no less than $832,000. Now, I say games. First of all, counsel points to the record 94, his letter from August of 22 responding to a demand. Nowhere in this letter is that 2019 lease referenced. We're all scratching our heads. He says in the letter that the 2015 leases are no longer effective.
I saw that.
Well, okay, why not? Well, one might mention the 2019 lease. That would seem.
They did in opposition to your motion, though.
But in the answer, so we file our complaint based on the 2015 leases. Under CPLR 3018B, they have an obligation as an affirmative defense. I want to get the language correct. A party shall plead under 3018B. A party shall plead all matters which, if not pleaded, would be likely to take the adverse party by surprise or would raise issues of fact not appearing on the face of a prior pleading. Look in that answer. No reference at all to the 2019 lease anywhere in the answer.
They were sleeping on it. They wanted to spring it on you in summary judgment.
They wanted to spring it on us in summary judgment. Not referenced in this August 22 letter, not referenced in the answer. It comes later as part of the opposition to the motion for summary judgment. But that's fine. We don't dispute it. Okay, we had the wrong leases to begin with. 2019 lease is correct. So, Your Honor, why would we didn't want to because this is all about delay. These games are about delay. We don't want to go back and restart, refile the complaint, go through all that when there was no dispute about the 2019 lease now. And so there's no question of fact.
Right. I don't disagree now going back, there's going to be a big delay, but I guess the question is like when they brought their opposition right back then and there, the delay would have been a month or two.
Well,
hindsight's 2020, right?
But Your Honor, there was no dispute, so we could conform the pleadings to evidence. The court didn't have any issue with us obtaining the relief. But the important piece, Your Honor, for ejectment is that the elements there's 3 elements. There's only one element that's in dispute, and that's that we as plaintiff, the landlord, have a present or immediate right to possession thereof. That's what they contest. That's what they challenge. The second element, that's the only one that's in dispute. And there, Your Honor, they don't argue that they paid rent. The argument is, well, there was some 10-day notice that was required, and that's what it's based on.
They say they paid additional rent, these things that should have been paid by the landlord.
They haven't, Your Honor, it's clear in the record, and there's no evidence of them paying anything. They haven't paid any rent, and any additional rent would have had to have been paid to the landlord under the terms of the lease. They didn't have an option to do that. So there's no rent that has been paid. No rent, no basic rent, no additional rent. That was in the finding of fact. But this language, and it's important, counsel says a couple of times incorrectly, he calls it a notice to cure. It's not a notice to cure that's referenced in this section. Importantly, it's a demand. But the most important part comes from this language. Why would there be a written demand? Because there's 2 parts to that sentence that the tenant is relying on. It says, in the event tenant shall fail to timely pay rent or any other amount required to be paid by the terms hereof, or shall be in default of or fail to perform any other obligation or duty provided herein within 10 days after bless you, written demand from the landlord to do so. So it's that second portion. If it's a rent payment obligation, that doesn't require any written demand because the lease already provides for that.
Judge Pace went with you on that.
Yes, correctly so. Not only because of the clear and unambiguous sentence that's right there, but if your honors look at the other provisions in the agreement, it supports that interpretation. In section 1 of basic rent, it says that rent shall be made on the first day of each month at the office of the landlord and shall be paid without any right of offset. In the first section entitled default by tenant, it says, and this is important, the tenant agrees to pay the landlord the rent above specified at the times and place and in the manner above provided. No notice is required. In terms of the
They're gonna
obligation.
know if they didn't pay.
I'm sorry.
Right,
They would know if they didn't.
Gotta know if
pay.
they
And
didn't
it's a
pay.
fixed obligation. Commercial landlords don't put in these types of notice provisions when it comes to rent, because otherwise they'd have to serve rent every month for a tenant to pay. It's just not there. There's also other provisions of the lease. For example, further down, it states that in the event of default in payment of any installment of rent or any other amount required to be paid by the terms hereof for more than 15 days, landlord may discontinue furnishing services. Again, it's the 15 days of not paying rent that triggers the right to not pay services. No, there's no notice required there either. So again, it's all consistent. There's no notice required in terms of the obligation of the tenant to pay rent and of a default occurring by the non-payment of rent. Another important point, council misstates that somehow we had to terminate the lease in order to be entitled to possession. We didn't have to terminate the lease. It's the non-payment of rent under the unambiguous terms of this lease that give us the right to possession. We had the right to terminate as well, but once they don't pay rent, we have a right to possession. We didn't have to terminate. Likewise, Your Honor, so again, with respect to the ejectment, there is no, and there wasn't at the time, any material issue of fact, whether it's the 2015 lease or the 2019 lease, no rent's been paid. And that was what Judge Pace correctly decided in terms of ejectment, that we were entitled to repossess that property. He did limit it to the space that was only covered by the 2015 leases, which is everything but that 9,400. And we went back later and we obtained an order for ejectment as it related to that additional space.
Do you want to discuss the bond real quick here? Keep on to the bond?
Yes, with respect to the bond, it's clear by statute, Your Honor, that 5519A6 is subject to 5519C. So even though, regardless of what 5519A6 may provide in terms of an automatic stay, the court clearly has the discretion under 5519C to vacate, limit, or modify any stay imposed by subdivision A6. So that was within the judge's discretion to include the past due rents, which I think the judge appropriately did. We do believe that it was that the stay shouldn't have been granted because we don't believe there was any merit to the ejectment, any defense that has any merit to the ejectment claim. So with respect to that, Your Honor, we believe that it was there shouldn't have been any stay imposed. And if there was an automatic stay under 5519A6, the court should have vacated it then under 5519C, because again, Your Honor, this tenant hasn't paid rent in nearly 3 years, and the client's entitled to obtain possession back. Your Honor,
Thank you.
any other questions you'd like me to address?
Thank you for coming in. The last case is 921 Trabert versus New York State Office of Mental Health. Attorney Greenwald is arguing virtually. Counsel Silverman is here, so Ms. Greenwald, you may proceed.
Good afternoon, and may it please the court. I'm sorry, I don't know if you hear an echo as well.
Sorry, do we care to echo?
No, I think you sound fine.
I'll proceed then. This court should follow the First Department's decision in Ajoku and hold that Supreme Court lacks jurisdiction here. The default rule recognized repeatedly in longstanding precedent is that money claims against the state belong exclusively in the Court of Claims. Indeed, the whistleblower laws here nowhere mention Supreme Court and generally state that a claim may be filed in a court of competent jurisdiction. For claims of money damages against the state, that is the Court of Claims. The statutory text does not support the anomalous result of concurrent jurisdiction, much less provide a clear waiver of the state's immunity in Supreme Court. The only new development since the First Department's decision is the 2021 amendment to the private sector whistleblower law, that Labor Law 740. That amendment said nothing about Supreme Court's jurisdiction over claims against the state. The amendment added a jury trial right to the private sector statute, which is generally applicable to all kinds of employers. But that general provision does not override the specific requirement that claims against the state be filed in the Court of Claims. And the legislative history for that 2021 amendment also says nothing about jury trials against the state in particular. This follows the general default rule that money claims against the state are not entitled to a jury trial, even though more generally against any other kind of non-state defendant, they would trigger a jury trial in Supreme Court.
Would you agree that, do I have this right, that prior to 2010, when the legislature amended the Court of Claims Act, lawsuits of this nature were routinely brought in Supreme Court?
No. I will acknowledge that the plaintiff here cites 3 decisions, 2 of which were after the Keskin decision and therefore understandably were brought in Supreme Court due to that confusion. But there is no evidence that they were routinely brought in Supreme Court between the time the whistleblower laws were enacted and Keskin or before the 2010 amendment. Indeed, the state commonly uses collective bargaining agreements that funnel these types of claims into arbitration, which is why we rarely see these cases against the state.
So
but what we do see here is a handful of...
Did the sponsoring memos, those who wrote those, and the legislative history seem to suggest that the purpose of these amendments was to expand the jurisdiction to give plaintiffs the option to sue in either Court of Claims or Supreme? Did they just had that wrong in their intent in the legislative history there?
Sorry, excuse me, Your Honor. My window closed for a second.
Yeah.
So I would like to point out first that it's the statutory text that governs here and not the legislative materials. But to answer Your Honor's question more directly, at best, those legislative history materials are somewhat ambiguous. And what we do know is that the legislature, 1, was repudiating the decision in Keskin, and 2, decided to add jurisdiction over these whistleblower laws to Court of Claims Act Section 9, where it has long been established that the claims in that section are within the exclusive jurisdiction of the Court of Claims. And to the extent that there was potentially some confusion in letters from a few of the state agencies, that simply shows that some of the stakeholders were confused, which is completely understandable in light of the Keskin decision, and that in fact, those stakeholders expressed concern about potential concurrent jurisdiction and supports the general policy rationale and the default rule that the legislature usually follows and followed here in putting these claims exclusively within the jurisdiction of the Court of Claims. I'd also just like to briefly address the coroner decision. As we noted in our briefs, that is basically the one major example we could find of any concurrent jurisdiction. It just really doesn't happen here, and that statute has unique features that are not present here in the whistleblower statute. The human rights law, as the Court of Appeals explained in Coroner, specifically grants jurisdiction to the Division of Human Rights over claims against the state that abrogated the default rule that jurisdiction is exclusively in the Court of Claims. And the human rights law also specifically grants jurisdiction to Supreme Court to review these claims that are coming from the Division of Human Rights versus the whistleblower laws here, which nowhere mention Supreme Court and only mention Court of Competent Jurisdiction to encompass claims against the state that must be brought in the Court of Claims. Finally, while this does not go to the merits of the dispute here, I would like to note that any dismissal of the plaintiff's claim here can properly be brought in the Court of Claims under CPLR 205. If the court
Thank you.
has-
Thank you very much. I think we understand your points.
I would just like to note, we would obviously urge the court to reverse here and dismiss the case. But in any event, the court should at least dismiss the labor law section 740 claim because it is only applicable to private employers.
Thank you, counsel. Mr. Silverman.
Good afternoon, Your Honors. Greg Silverman for Plaintiff Appellee Melissa Travert. First, this case largely deals with the concept of sovereign immunity. The legislature has the power to decide when the state may be sued. And I ask Your Honors to specifically look at Civil Service Law section 75B. There it specifically says that state employees can bring a whistleblower claim in a court of competent jurisdiction. Now, competent jurisdiction is defined as a court with the power to grant the relief provided for in the statute. So what happened, and obviously the Supreme Court has the power to grant the relief set forth in Labor Law 740. Let's back up. Legislative history, we have two Court of Claims decisions. The Keskin case, or first the Taylor case and later Keskin. Taylor was a claimant, a state employee brought a whistleblower claim. There the state said the Court of Claims has no jurisdiction because all of the relief in Labor Law section 740 is equitable in nature. The Court of Claims lacks equitable jurisdiction, and therefore that court said that claimants should be advised that they should bring claims in Supreme Court. As far as we know, I cite a decision from 1992. The state was defending these claims on the merits in Supreme Court. The state didn't have to do that because unless the legislature waives sovereign immunity, the state can say, we didn't agree to be sued. The state could have said, you can't sue in the Court of Claims. You can't sue us in Supreme Court, and we're not going to entertain any state employee whistleblower actions in either court. But we know that the state litigated these cases on the merits in Supreme Court. After the other Court of Claims decision in Taylor, this was about a decade later, and the Court of Claims said, since our decision in Keskin, the legislature hasn't acted, we still don't have jurisdiction to provide wholly equitable relief. And therefore, again, you should go to Supreme Court. The legislature didn't like that. They thought the state employees had plausible claims and they shouldn't get kicked out of the Court of Claims if they wanted to. And so the legislature obviously acted to say, you can bring claims in Supreme Court presently. The bill sponsor memo, as Your Honor mentioned, said that. Currently, Supreme Court has jurisdiction, and there is no reason to preclude the Court of Claims from having jurisdiction. So it amended the Court of Claims Act. It included as claims that the Court of Claims Act has jurisdiction over, specifically referencing both Civil Service Section 75B and Labor Law Section 740. Now, in Court of Claims Act Section 9, it lists the claims that the Court of Claims has jurisdiction over. Contract, tort, etc. Section or paragraph 13 of that section is the only provision that says the Court of Claims has jurisdiction over separate statutory claims, which in and of themselves already say that can be heard by a court of competent jurisdiction. Obviously, the Supreme Court has jurisdiction to render equitable relief. I'll also mention that Specifically, Section 75B is about state employees bringing a whistleblower action. If the legislature wanted to preclude state employees from going to the Supreme Court, it could have amended that statute specifically and said, instead of saying that state employees can bring their claim in a court of competent jurisdiction, we're going to amend that statute specifically and say state employees can only go to the Court of Claims. Of course, it did not do that. State employees still have the right to bring their case in a court of competent jurisdiction. The other aspect of this case I'd ask your honors to review is the remedial purpose of a whistleblower statute. Is that state employees, there's a public interest in having state employees bring retaliatory actions to light. If they believe that there's illegal conduct happening in state government and they are retaliated against for bringing that issue to their employer, we want these claims brought. We want this potential fraud, waste, and abuse exposed. And of course, state employees who bring that fraud, waste, and abuse to the public's attention, we want them compensated if they are retaliated against. There's case law cited in my brief that says there's a strong public interest in that. But here, by cabining state employee whistleblower claims in the Court of Claims, they are prevented from potentially having any equitable relief, reinstatement, and injunction. Secondly, they wouldn't have a right to a jury trial specifically laid out in the statute. And potentially, most importantly, they wouldn't have the right to obtain attorney's fees upon prevailing. Now, of course, typical state employees, they're not making much money. They don't have the resources for a long fight against the state. And of course, the state is going to, just as it's doing here, try and suppress those claims. And so I understand that Ms. Greenwald referenced there's a First Department case, 2021, that says the Court of Claims only has jurisdiction. I would submit that case has no analysis whatsoever that the specific statute, Section 75B, says state whistleblowing, state employees who are whistleblowers can bring their claims in a court of competent jurisdiction. That is clearly the Supreme Court. This is a remedial statute, and remedial statutes are to be interpreted to promote justice and assist state employees who are bringing potentially unlawful conduct to the light of day. And so by saying state employees can only bring their claims in the Court of Claims, they can't get attorney's fees, they can't get a jury trial, they potentially can't get equitable relief like reinstatement and injunctions. And so in this case, if this court agrees with the state employee whistleblowers are effectively kneecapped. They're silenced from bringing these claims to the light of day. So barring any questions from your honors, I ask that the court affirm the decision of the lower court dismissing the state's motion to dismiss.
Thank you, counsel.
Thank you.